Yes. Listing of a work motion. You file an IA. You consider. When did you file? When did you file the IA? Okay. So you are the petitioner. You want extension of the interim. We'll have. Use the microphone.
It is not complied with, my lord, and petitioner has suffered.
Orders. When did you file? Case of
File
which
long
year?
back notice issued, my lord, but the process is going on. They have not complied with, my lord.
Next week. Next
Next week.
Friday. Case of which year? Case of which year? Case of which year?
It was written on August.
Okay, next week. Wednesday or Friday.
What is
Similar. Similar.
one was set on 31/5/20, but no order has come.
Case of which year?
Which
You already have it on Friday. Friday. Next Friday. Yes, Madam. Next Monday. Monday, many matters are fixed. Here for the petitioner. It will come up for the first time. Have they filed their response or not? Okay, Wednesday. Use the microphone. Yes.
Item number 28, Lord.
Yes.
Can it be at two, Lord? I have filed IA for condemnation by my offender. My offender has been already condemned by the government. Cabinet.
Where to?
Lordship, several times, Lordship, it has been not issued, but today, Lordship, the appointment has been going on, Lord.
We'll have it before two. Why should we wait till two? Come up before two.
Last item, Lord, 28.
Understood. Why 20 it will not reach before 2 o'clock?
At 2, Lord.
If it reaches in usual course before 2, why should we wait till 2 o'clock?
Lordship, but in this case, Lordship, in your case, we have been engaged. In section can yes, if maybe
You say that you are saying of upgrading. Matter will reach at 12 o'clock.
at
Okay, taken up.
Lord.
Item number 28.
28.
No. Yes. Which what matter? Ministry. Notices have been issued. And now what is the stage? They have filed the affidavit. What is the matter about? Seniority. Okay, we'll have next Wednesday. I don't think the microphone is on. Check. Check. Yes. Speak loudly. Your voice is on time. On time. Speak loudly a bit.
I beg to for
On time.
matter placed for
speak a bit loud. We have to hear you.
I beg to mention to petition after the
Petition for what? You want listing of those matters? When? Next week. Matters of which year? 23. Why next week? What is the stage of the matter? Matters are at what stage? There are different stages of the matter. Admission, orders. Not next week. You come there thereafter. We have already fixed many matters and matters. Right. The week thereafter. We put a date. We'll have. Yes, madam.
May I page lordship, I take to mention for listing of a WPC for admission. Matter relates to selection of GB president of PP Solid.
Selection of?
GB president.
Selection.
Selection and lordship already selected.
You
which-
selected the president of a Gaon Panchayat.
No lordship, PP Soliha College.
Oh, governing body.
Lordship.
You say governing body. Okay, well, not next week. On we'll have it on the Monday. Week thereafter. That will be on 5th.
5th of June.
5th.
Of life.
May I please, Lordship, I beg to mention for listing, Lordship, in admission, Lordship. Matter
Yes,
related
matter which year?
22, Lordship.
5th.
Of
5th June.
May it please, yes, my
What is it?
My lord, this petition for my lord relates to selection for particular selection process, my lord.
Notices are yet to be issued.
No, my notice has been issued, my lord,
Okay.
on many occasions. Matter has been listed, but it was not listed for a long time.
Yes,
law point
yes. Mr. Sharma, you are appealing.
Yes, my lord.
File your affidavit.
My lord, we have received the instruction, my lord. Here, on last occasion, the Honorable Court has directed us to place the instruction, my lord. So we have received the instruction here, my lord.
Based on the instructions, can we take a decision, or you would like to file an affidavit?
Yes,
My
my lord.
May I submit, my lord?
Yes.
Sir, this is a pure law question is involved, my lord.
Yes.
On the basis, if your lordship pleases, my lord, on the basis of the instruction.
What is the issue?
Issue is, my lord, the petitioner in both the cases, they were, my lord, get qualified. They belong
Get
to
qualified.
Yes, they belong to OBC category. Lordship knows, my lord, for OBC, the qualifying mark is 55% in both the papers. After being qualified, an advertisement was issued for a postgraduate teacher in a particular subject. Both the petitioners, their name were recommended as the most meritorious against the post which was for open category. But for the fact that the petitioners were not getting the 60% mark in the qualifying that examination, their appointment has not been made.
In the selection, you had scored marks over others.
Yes, yes.
And
apart from that,
the issue is on the qualification factor.
qualification. And that on other aspect, my lord, the petitioner never availed any relaxation as regard being a candidate of reserved category candidate. Had it been a case that
Mr. Sharma,
Yes, my lord. Yes.
what do you say?
My lord, they have not get the 60% marks in their
So
examination,
there
my
are
lord.
two issues involved, not issues, two components involved in this issue.
Yes.
First is the qualification,
Yes.
eligibility.
Eligible.
That is the threshold to enter into the zone of consideration.
Yes.
Now, in the zone of consideration, if you, as an OBC candidate, if you secure a particular mark in the TET, you come within the zone of consideration.
Yes, ma'am.
He came in the zone of consideration. You cannot oust him,
Yes.
or both the petitioners. Now, in the main selection, they have secured marks more than the unreserved category.
Yeah.
The law is that if the mark is more than unreserved, he will be treated as a unreserved category and will be offered.
Yeah.
Now, you cannot now fall back on the fact that he did not qualify, he did not secure 60% in research. That is not required for an OBC candidate.
It is an open.
post is open category, there is no doubt about it. My lord, my submission is that, my lord, since that is only qualifying,
We have filed a affidavit.
Already, my lord, 2019, my lord.
What is the stage now?
My lord, that post has not been filled up, and an order was issued by this honorable court. Any appointment is subject to outcome. We have communicated that order, my lord.
They have not made any
They have
appointment.
not made any appointment. Even after, my lord, if any appointment is made, my lord, that option is always there, my lord. Lordship has passed an order on the earlier.
No, if they are making an appointment, they will certainly not appoint you. So better to
No, they
have,
have not made any appointment. As
no,
per
better to
my-
have this position maintained. We'll have it, we'll fix the date. We'll ask them to file the affidavit. This point we can resolve. I think
Right.
there's not, should not be any difficulty. But since nothing is on record, let them put it on record.
A short date may be given,
Yes.
my lord.
T. Chakraborty.
T. Chakraborty.
Urge T. Chakraborty learned counsel for the separate order. Similarly situated.
Similarly, serious schools are different, my lord.
Understood. For the petition. It appears that notice of motion was issued in the year 2019 itself. However, no returns have been filed till date. Sri U. Sharma, the learned standing counsel, Secondary Education Department,
Secondary education.
however, submit that instructions have been received. Para. After hearing the parties, it appears that the issue can be resolved upon filing of the affidavit based on the instructions. Accordingly, let the matter be listed after 3 weeks to enable the respondents to file their affidavit. An endeavor will be made to dispose of this petition at the admission stage.
Can it be date be fixed, my lord, for us?
Tell us,
Any date?
after a list on today is 25th.
My lord.
We'll have it on 19th of June.
19th. I'm deeply obliged.
Both is separate.
Out of this matter, my lord, because of the wrong interpretation of law, and my lord, in fact, my lord, he was personal appearance was given, he inspected the area, and even in spite of the all direction, he has not done it, my lord. Your lordship kindly see page 22, my lord. Page 22.
22.
Page 22.
Well, just one.
Students are
You are a college.
Yeah, it's the Kamala, yes, Kamala Besborua Memorial College. It is one of the oldest BT college in Assam, my lord. It is in Donat, my lord. And that your lordship kindly see page 22, my lord.
22.
Page 22.
Yes.
Page
I think this matter a long time back we have heard. We have heard.
I'm just submitting matter. Now,
We remember this.
in spite of repeated order, they have not corrected. And my lord, they were asked to give him personal appearance. And they were asked to, my lord, move around the Guwahati city. You see the Assam type house as a permanent house. Assam type house is, my lord, your lordship kindly see this picture. Your lordship kindly see picture that, my lord, top of the, my lord, top, my rooftop. That part they have taken as a temporary building. Well, it is a permanent construction. All the, my lord, here is a Chief Justice Bangalore is a temporary building, according to them, my lord.
Yes,
So
yes.
that is the case, my lord.
My lord, we have filed our affidavit, additional affidavit also. This is a statutory violation, my lord, under section 32 of the NCP Act, and the 32, the rules to regulations are obtained as per regulation 8(7). That is a
What is the requirement of 32?
that should be a permanent, my lord. In our affidavit, we
That
have
is
specifically
the, my
stated-
lord, part should be.
This is not a permanent according to you.
Yes, my lord.
Why?
Because, my lord, this is not a building, my lord. It's a in the CI sheet above the top of the building.
No, is it a
It
one?
is a CI sheet, my lord.
Is it a one-story building?
Two-storied building, my lord.
If it's a two-story building, whether it's CI sheet on the top, does it make any difference? Will it become a temporary structure?
Three-storied, my lord.
Three-story building.
Three-storied building.
No, my lord,
And top of the building, my lord, it's a CI sheet, my lord. So far as our We have already taken up this matter, my lord, on 3 occasions in our regional committee meeting, and regional committee held that, and which I have already in my additional level I have announced, my lord. They have stated that as per regulation 8.7, it's a statutory violation. This is not a permanent structure.
Okay.
That is our stand, my lord.
Okay, we'll consider your stand.
Your lordship may have the matter. I will satisfy your lordship on the next day, my lord. 30th.
Today, why not today?
My lord, your lordship
That
kindly
is,
see,
my
my lord, your lordship kindly see a law, let a rule, my
No,
way is
no,
effective.
we
That
can
is,
hear
my
it
lord,
today.
not speaking about.
Okay, let him have some time on Tuesday for disposal.
Tuesday.
Tuesday for
Let it
disposal.
be a part heard, my lord. as a final
Not part that we are here. We take care of it.
What are all the problems?
But in spite of the orders, if this is your
No, my
stand,
lord,
No, my lord, this is a statutory violation, my lord.
if that is your interpretation of the statute, if that is and if we hold otherwise, then we may impose heavy cost upon you. A 3-story building with corrugated sheets on the top, if you are holding it to be a temporary structure, then I think you have serious difficulty in your understanding.
and very.
I will try to satisfy you on next day.
What is there to satisfy? That is the only
Since, my
point.
lord, since my lord, this is specifically, my lord, your lordship may kindly peruse our regulation.
We are not questioning the statute.
That's why, my lord, we have taken.
Are you
a
questioning the
decision that
statute?
This is not a permanent, this is a temporary structure.
But very interesting, statute does not say so, my lord.
So far as also, my lord, building bylaws in central government building bylaws, there is a building, the definition of building which is a permanent structure. That is bricks and stands and which I
This
have.
building does not have bricks and sand.
Bricks and sand is there, but what above the top, my lord, this is CI sheet, my lord, and which is not a, so far as our regulation is concerned, this is not a permanent structure, it's a temporary structure.
But even
You make your argument, we'll consider. We'll consider. But be ready with all consequences.
Yes, my lord.
You seem to be very confident.
No.
Let us see. Yes, on Tuesday.
My lord.
Mr. Alam, be reasonable and ask your officers to be reasonable.
so even
Don't
laws
try
are-
to act
my lord,
very
they have-
smart.
they have
My
wrongly
lord, in
interpreted.
compliance, your, my lord, in
Don't try
compliance, your
to
lordship-
act too smart.
My lord, in compliance, your lordship's order, we have already 4 regional committee meeting, my lord. There are regional committees, my lord. Not a single officer, my lord, but
If Mr. Alam, if you have disputed that this is not the building, a
it's not a
3-story
permanent structure, my lord.
if you have disputed that this photograph is not the photograph of the building in question, it is a temporary structure with thatched walls which are temporary in nature, half walls. This is a 3-story building.
That is the problem, my lord. Since, my lord, above the top of the building,
What
my
about
lord, this
the
is
what
stage.
about the residence of the Honorable Chief Justice?
That is there, my lord. We are not
Temporary
concerned-
structure.
No, my lord, we are not concerned with this. Is a pan India the regulation, my lord, and all the colleges have abided by this regulation. And there is a some
Okay. You also bring your inputs on what is the A-type house.
My lord.
Is it recognized in the engineering parlance? It's called an A-type house, not a some type. You get the feedback. It's a recognized mode of construction in engineering. If you are not aware, we can apprise you. Get those instructions. Madam, you are for whom? University.
My lord, no problem.
Okay. Heard TJ Mahanta London Senior Counsel for the petition. Also heard the Alam for you for
LCT, my lord.
NCT. Whereas MS MDB counsel has appeared for the which university? For the Dibrugarh University of Sarah. The readings are complete and the senior counsel for the petition expresses some urgency full stop, considering the facts and circumstances and also taking note of the previous orders passed in this proceeding, list this case for admission
Admission hearing,
on Tuesday next
30th, 35.
30.
Obliged, my lord.
Lordship, item number 4 and item number 24 are almost same, Lordship. Same issue, Lordship, with regard to validity of my PhD thesis. Lordship,
Matter may come on other day, my lord, along with another case, my lord, with the same petitioner. WPC number 4291 2017, my lord.
Connected.
Connected
all the
Uh,
matters would be hard to Lordship together, Lordship.
on a
there are-
hearing day.
you are the respondent.
Yes, I'm the respondent.
Okay. Heard free SK Das when it comes for the petitioner, whereas free B Purkasta has appeared for the contesting private respondent. Full stop. You are also appearing. NIC. For
NCT.
NCT. And state is also a party, you know.
Secondary division. Secondary division, my lord.
Secondary, who's there? P. Bora. You also heard three. U. Sharma, Lieutenant Counsel, Secondary Education Department, whereas Sri Alam has appeared for respondent NCT. Para. It transpires, and this court has been informed that there is a connected writ petition being WPC
4291 2017.
4291 2017, which, however, has not been listed. Para. List this case on
8th of June, my lord.
8th of June, on 8th of June, along with WPC. So,
4291 2017.
In fact, Lordship, the issue has been decided in the writ appeal, Lordship. That
you place it.
obliged.
Mr. Dekar.
May it be, Lord. Actually, at one point of time, Lordship, this matter has been hard at length and supposed to pass over, Lordship, but unfortunately, not happened, Lordship. Lordship, the matter relates to Lordship suspension, Lordship. Petitioner was placed under suspension on 21 December 2017. Lordship will find at page 21, Lordship.
You are a teacher over.
I'm still Lordship, graduate teacher, Lordship. I have been promoted to the post of principal. Now, allegation is that I have
The suspension is in the position of a principal.
Yes, Lord. Lordship, kindly see the impugn order.
You are still under suspension.
Yes, Lordship.
What about the DP?
Nothing is happening, Lord.
Yes, yes.
DP is not drawn, not even the suspension order is extended. So, in view of order, so they will be squarely covered.
Yes, yes. Mr. Sir.
Better procedure, giving de novo inquiry in the meantime, this order is necessary.
But in this matter, other occasion, SMT 60 was appeared, my lord. So,
And
But the DP was initiated in 28th of September 2019.
but they have not taken any decision, Lordship. Lordship, kindly see, even thereafter they have harmed his focus, nothing also. Here also, Lordship, they have not given the list of documents, list of witnesses, nothing, Lord.
What is the present status, Mr. Sharma, of the DP?
DP is not issued, my lord.
So far, my knowledge is concerned, Lordship.
You come to page 10. 10 is the show cause notice.
My lord, I may be allowed to call Mr. SMT 60, my lord.
Call him. If you require, we may grant you some time till Wednesday. But call him. If is he there in the court today?
Yes.
You call him. So take after.
Yes,
After some time, my lord, he will come.
Lordship, take after some time.
Yes. Mr. Mazumdar,
Lordship.
what are these
Lordship,
matters?
my lord, place our case past, then I will place because it's a similar matter, Lordship, regarding non-consideration of the
Connected matters.
connected.
Mr. Fukan, file your return.
Apart from
Lordship, what has happened in this matter, Lordship? This matter was actually taken up on 18/11/2022. The order has been given to us on has been made online on the last week itself.
But there
I
was
have received it.
something to be done by you.
My lord, we were supposed to file an affidavit, so the order was not online. It last came up on 18/11/22.
No,
On the last occasion,
that will take care, but where is supposed to be,
we were
we're
supposed to file a,
only the affidavit part.
yes, Your Lordship, but we
Have
didn't
you
know
got the
what the,
instructions?
my lord?
Have you got the instructions?
No, I got no instruction because Your Lordship, the order was not online.
No, that
So we didn't
you have said that you did not renew.
So
not
Lordship,
repeat.
sometime may be given to us because we have
In
to
the meantime,
ascertain.
Lordship, I pray. Our appeal is pending before the authority, Lordship. Let them.
We'll say pendency shall not be a bar for consideration of the appeal.
Lordship, because annexure, they have received.
You, madam, you are similarly placed.
Yes, Your Lordship.
Appeals are
But,
pending.
We made a representation pending, but Lordship, what we're praying for in an interim order.
My lord, that
Lordship, may I
will
just
not
take
be
2 minutes and tell you about the case?
No, 22 matter. Let him file the affidavit. There is some
No, no.
technical
No, but
issue.
what is happening is, no, Your Lordship, what's happening is they're coming up, this is a checkered history. Finally, in 2011, the screening committee comes in and gives 4 categories of people who are working validly, they should be paid, so there was no problem. Then there's the third category is what concerns all of us, is what we were found to be not eligible. We were found to be not eligible, but working.
Now, what kind of interim relief are you seeking?
Lordship, what has happened is they are continuing. There's a list of 600 people that they've come up with, out of which they're randomly picking up from that. We also belong to that 600. They've picked up 169 from that, from the other category, which is not working. We have averred and we have shown our list. They were not even working. They picked up 31 from there, and the rest are from where we don't know. So this final 302 people who they want to appoint only contains 161 from a valid list, of which we are also a part of. The valid list is 620, of which they picked up 167. The
You are not
rest-
amongst this 167.
But
You're
we are
left
not.
out.
That's
You're
what-
left out from the.
Our grievance is that similarly situated people have come in.
Now, what is the?
Lordship, our concern is that
What
they're
is the
going-
interim relief you are praying?
Lordship, they must not. They've already come up with a list of 302. We don't want to disturb that. We're not saying a safe or fear of that. They must not go further and appoint other people, absorb other people, without considering us, because we are first in line. That is our only concern. And Lordship, if I place facts, it's
No, without this returns, it not be
My lord, we have to
proper
file
to-
an affidavit, my lord, because the 300
They must-
What are you contemplating? Are you contemplating to fill up the further post?
Lordship, at the moment I need my instructions because we don't know as well.
We'll do one thing.
Just come up, my lord.
We'll do one thing.
We need
We'll
file a
fix
detailed
this,
affidavit.
we'll fix this matter on Wednesday next,
Yes.
enabling you to take the instructions.
Yes, my lord.
If you think that you need time to file affidavit, we'll grant it. Wednesday, we may consider if we can pass any interim order.
But my lord, if the prayers need to be checked also, my lord.
no, we are aware of our prayers.
Uh,
The
no,
last occasion, Your Lordship, the court had said, please apprise. This
My lord, on the last occasion, we have received it last week only, the order.
affidavit, no, apprise for Palestine.
But
Heard
order was
three K.A. Mazumdar as a common order, huh? Heard the learned counsel for the petitioners. Also heard three A. Learned training council, elementary education department. Three Fukan, the learned training council, however, submit that due to some technical issue, the order passed on the last date, that is 18/11/2022, could be obtained very recently, and therefore instructions could not be obtained in the meantime. He accordingly prays for some time to obtain the instructions. On the other hand, there is a prayer from the side of the petitioner for consideration of the interim relief. Having considered the in view of the aforesaid situation, let this matter be listed on Wednesday next to enable free who can to obtain the instructions. It is instruction. The next, it is made clear that the next date is fixed only for the purpose of consideration of the prayer for interim order, and depending on the instructions from this court, may also consider grant of further time to file the affidavit of it. Pendency of this writ petition shall not be a bar for consideration of the appeal of representation submitted on behalf of the petitioner.
Thank you,
Petitioner.
Lordship.
Lordship, in fact, Lordship, this case is listed after a long time, Lordship. In fact, we have also placed the file yesterday in a case out of
We just want to know one
within a
thing.
week, Lordship. I will get the
And we'll
instruction.
grant you time. He is basically against an order of
Suspension,
suspension, but it appears at page 10, I think,
Yes,
there is a show cause notice,
yes, sir.
which was from which it appears that the DP was already initiated.
Yes.
You need to take instructions. What is the stage of the DP?
Yes, yeah, yeah, exactly. Yes. I'll get it.
Aid accredited counsel for the petitioner. There are also heard three SMPC, Learned Training Council, Secondary Education Department of Terra. PCC, the Learned Council, however, submits that the instructions are yet to be obtained, and some time may be granted to him to obtain the same court of Terra. Considering the nature of the case, we'll have it next Friday.
Yes.
Let this matter be listed on 2nd of
Yes.
June
Yes.
to enable
Yes.
the Learned Training Council to seek to obtain instructions. Specific instructions are to be procured with regard to the case of the departmental proceeding initiated by the show cause notice dated 29/2019, which is September.
Okay.
May I please? This matter regarding the compensation appointment. Sir,
My lord, I have bring the instruction.
You have the instruction?
My lord. I'll kindly see my lord, page 3, my lord.
Page 3.
My
Yes.
lord.
What is there?
My lord, may first prayer, my lord, may kindly be seen, my lord, secretary to CM as for the petition in respect of Himajyoti Sunwal of Sisar district, who has prayed for appointment of compassion. If agreed to me, may be perhaps forwarded petition to DC Sifagor for necessary action. Now kindly see, my lord, para 3, my lord.
Yes.
Please write to the petitioner that appointment on compassionate ground recommended by the concerned DC only.
DLC.
My lord. Accordingly,
right.
my lord, this letter was issued by the additional secretary. My lord.
Which letter?
My lord, letter dated 6 December 2021.
Elective.
Thereafter, what has happened?
Last occasion, my lord, this honorable court was directed me to bring instruction regarding this letter.
Annexure
Annexure 5. Page 23.
22.
23.
Yes.
It's a letter written by the additional
Your name is Himanta Jyoti.
Himantu Jyoti.
Yes.
In this case, your lordship, the main concern is this page 33 here. That is,
And did you apply through the proper channel?
Yes, Your Lordship. Because PS 33 doesn't say that, Your Lordship.
Page 33 is the consideration.
Yes. Only there is no seal and sign of the authority. But they got the application, my application,
33.
33 Your Lordship. As per the government office memorandum,
Himanta Jyoti, yes.
Yes.
Applicant should apply for appointment of
the
within 1 year.
applicant should apply for the appointment compensation ground within 1 year. As per the record in the original application submitted on 27/2016, no seal and signature seen on the body of the application of the concerned authority at that time. Later on, another application was submitted on 27/12/2021 for the appointment on compensatory ground.
Yes.
So they got the application, but only the objection of that application is there is no seal and sign of the authority. So it is not the fault of the petitioner. He has submitted to the authority.
You have the record? When was this recommendation? 22.
Page 33. Report C.
See, it appears that you had not routed through the proper channel. That is why there was no seal and sign. You had made an application before the,
Elementary.
no, not elementary, the application was made, but it was put before the Honorable Chief Minister. And the Secretary had
The letter
sent the same to the DLC. Obviously, it does not come to the proper channel.
Your Lordship, I have submitted the format under which I have to apply. It is
And you
case
submitted
19
before whom? Submitted before whom?
Before the district elementary officer.
Where?
Sipsagar. Page 44, Your Lordship, in vernacular language.
I don't think you are correct.
It is there, Your Lordship.
No, the application is there, but it was not routed to the proper channel.
I have submitted.
Otherwise, what is the what reason will they have to write a note of this kind?
No, seal and signature is not there.
Not there. It's
Not
obvious.
there, but there
You can show this to your colleague, Mr. Bora.
My lord.
Show this to the first part. What is to the petitioner, not the second. Second is so somebody else, Rina Datta. So the first, he may not be aware of this. First paragraph. Please read. Please read aloud.
Yes, serial number 92-226.
Yes, please
So
read.
kindly be seen. The Secretary to CM Assam has forwarded the petition in respect of Himanta Jyoti,
Imanjoti is you, aren't
Yes.
you? Yes.
Zonal of Sipsagar district, and who has prayed for appointment on competition ground. It is agreed,
If agreed to,
if agreed to,
we may perhaps
perhaps forward the petition to PC Sipsagar for
necessary action. And second is not yours. Second is pertaining to
the
some.
Secretary to the
No,
CM
no.
Assam.
That is Rina Datta. That is not pertaining to you.
Okay.
Come to the
Please
next
write to the petition that the appointment
on competition ground is recommended by concerned DLC.
concerned DLC.
Yes.
write to the petition to furnish dates and other details regarding.
That is not for you. That is for Rina Dutta. This is for. Please write to the petitioner that the appointment on compulsion ground is recommended by the concerned DLC. You have to go to DLC.
Here in this case, Your Lordship,
This
this thing has happened in the year 2021. But initially, I have submitted the application in the year 2016 itself. Because that has been not considered since long. Then I have filed petition to different authorities. Your Lordship.
Mr. Bora,
My lord.
he may be correct.
My
The
lord,
16 application did not have seal and signature.
Yes, true, my lord. My
But
lord.
what about the application on in 2021?
My lord.
And the rejection is only because of lack of seal and sign.
My lord.
Lack of seal and sign is only pertaining to 16, not to 21.
Yes.
I think one consideration would be necessary. This doesn't appear to be done with any application of mine.
My lord, he has to apply within 1 year, my lord. For the
He
notice.
had applied, there was some defect.
My
Will you
lord,
find fault with him?
My lord, that is true. my lord.
And the application to the in the office of the chief minister was only in the year 2021.
My lord, my lord.
And if the 16 application was not signed,
Neither my
on that perhaps you cannot attribute fault on the petition.
My lord, probably because here seal of the
If he has not applied, then matter would have been different. He had applied.
signature and seal of the
Yes,
headmaster is there.
one time consideration.
My lord.
Principal this.
My lord.
What had happened on the last occasion, 26/4?
The record has been
Long order has been.
Well, on that day, my lord, I have directed to bring this inspection
Yes,
regarding the communication dated 6/12/2021, my lord.
We don't think that elaborate order is necessary. Heard. This is item number
9.
heard 3N and Upadhyay, learned counsel for the petitioner. Also heard 3P Bora, learned standing counsel, elementary education department, as well as MS D. Das Burman, the learned state counsel, Kolkata, considering the subject matter in dispute and the instructions obtained by Sri Bora, this petition is taken up for disposal at the admission stage or what?
Yes. No, motion stage.
Notice is yet to be issued.
Notice has not been. No notice has been issued. Only the instruction is.
At the motion stage, full stop. However, it is to be, however, this court has noted that this matter was filed in June 2022 and had come up for consideration on a number of occasions when this court had directed the learned standing counsel to obtain instructions for Kapera. The projected fact in this petition, no, the issue involved is a claim for consideration for appointment on compassionate ground. The fact projected is that the father of the petitioner, who was an assistant teacher of Tehingmukh Teteliguri MB School, Sibsagar, had died in earnest on 26/3/2016. The petitioner, claiming to be eligible in all respects, had accordingly filed an application in the prescribed format on 20/7/2016, praying for appointment on compassionate ground. Full stop. The petitioner was not informed of any consideration of such consideration of his application. Full stop. However, comma, after about 6 years, comma, he was informed that a meeting of the DLC was held on 12/1/2022, wherein the claim of the petitioner was rejected. Full stop. The reasons prescribed in the said meeting was that though an application was submitted by the petitioner in the year 2016, comma, there was no seal or signature. Full stop. As regards the subsequent application dated 27/12/2021, comma, the meeting, the minor also referred to a subsequent application dated 27/12/2021. However, the reasons prescribed for rejection is that the consideration could not be made as the application was not authenticated due to lack of seal and signature of the concerned authority. Full stop. The aforesaid, the relevant part of the consideration is appearing from the minutes of meeting dated 12/1/2022, which has been communicated on 13/1/2022, is expected herein below. Page 30. Yeah? It's open. Para. The Upadhyay learned counsel for the petitioner accordingly submits that the aforesaid rejection is liable to be interfered with a direction for a proper consideration in accordance with law. Full stop. Para. Sri Bora, the learned standing counsel, has placed before this court the written instructions received by him along with certain documents, along with certain photocopies from the note sheet. Full stop. It appears from the same that in the year 2021, comma, the petitioner had made further endeavors for his appointment on compassionate ground, and accordingly he was advised to apply to the DLC, which appears to have been done by the second application dated 27/12/2021. Para. Though it has been projected that the rejection of the application of the petitioner is on the ground of the same being time barred, comma, a reading of the impugned decision does not reflect the same, and the reason is a different one which has been stated above. Full stop. Para. It is a settled position of law that one-time consideration unmarried is necessary for every application which has been filed for appointment on on compassionate grounds. In the instant case, the reasons assigned for rejection does not appear to be germane and cogent as because of two counts. Also, firstly, no fault can be attributed to an applicant, to an aspirant submitting an application for compassionate appointment if the seal and signature of the concerned authority is not there. Full stop. In fact, when the application had reached the DLC for such consideration, lack of signature or seal on the state application of the concerned authority should not have been a reason, and at least the petitioner could not be made, and at least no fault can be attributed, could have been attributed to the petitioner. Secondly, non-authentication. Secondly, though delay has not been cited as one of the reasons, it cannot be held to be an unreasonable step on the part of the petitioner to apply afresh by the application dated 27/12/2021, more so when his approach to the authorities had also culminated with such an advice, which is revealed from the notice. In view of the above, this petition is allowed, and the impugned minor submitting pertaining to the consideration of the case of the petition is interfered with. Subsequently, it is directed that the case of the petitioner for appointment on compassionate ground be considered by the DLC afresh on merit. Such consideration is, however, required to be made strictly in accordance with law, holding different. The aforesaid consideration be made in the next meeting of the DLC. The photocopy of the instruction placed before this court is made part of the record. Do you have this note sheet copy?
Yes, yes, sir.
What is this? Good. It is also made clear that an issue of authenticity of the application was raised, the veracity of the application and the fact and the details of the same may be verified before such consideration. Yes, what is this?
Today's government ceremony is going on. But what happened? My 10 marks against the carceral is not given, and that's why I'm not. Whereas I am the one of the famous politicians receiving CCRT scholarship CCRT means Center for Cultural Resource and Training, Government of India.
Some marks are prescribed for cultural activities.
Yes, sir. 10 marks.
That marks have not
Not
been allotted
invented.
to you. If
But
those,
all are
if those marks are given, you come within the zone of consideration. Yes, yes.
Well, I've received the instruction.
Hmm.
Well, there is a committee which has been constituted for examining the cultural and the sports certificate. The committee has refused a stay on the ground that doesn't come under the terms and conditions that is mentioned in the advertisement. Advertisement says, only who represents the state in any
Cultural event,
they will be eligible for the mark.
What was the claim of the petitioner regarding her cultural
The
activity?
certificate which they have annexed at page 25 is a Center for Cultural Resource and Training. It says, it doesn't indicate anywhere that he has represented. Page 25.
25.
26 is invitation letter.
What is your discipline?
I am OTC.
ODC.
OTC. And next, 25 is certificate at page 26 is invitation letter. Especially I am invited to perform the pageants.
No.
Out of
Your invitation will not do. Have you represented the state?
You kindly come to page 27.
27.
27 of the year. It was issued by the Dr. Madhurima Goswami, head of the Chandra Baba Soikyani Tezpur University, where it is basically attended certified that Mr. Asmita Bharata, that is the present, received the Seniority scholarship in the year 2006 under the TTS as the first OTC dance scholarship holder in Assam. He represented the state of Assam in Hyderabad in the year of 2000.
Yes,
here certificate here.
This is a certificate, the certificate which they have annexed at page 25. This nowhere indicates, this is some documents taken from the director of KKIPA. Dear Lordship will kindly see page 22.
What is this KKIPA?
There is a Kasina Krishna Priya Institute of Performing.
What is the legal status? Is it a government thing?
It is a organization under the cultural department of October, and it is under in the Tezpur University. There are Chandra Baba Soikyani cultural, especially Indian.
This is Kasina Krishna Priya Institute of Performing Arts. This has got
some
nothing.
institute, maybe it is affiliated by the.
No. Where is the link with the Tezpur University?
No.
You are Mr. Kakoti.
Kindly come to page.
You are Mr. Kakoti.
Yes.
You may be correct, but where is the link?
Kindly come to page 6.
6.
6.
Yes.
Yes. Clause 7,
Yes, we have read this.
Petitioner begs to state that he is a certified awardee and recipient of the scholarship in the year of 2005 under the tutelage of Guru Dr. Madhurima Goswami.
No, that we have read. He may be also the head of the particular center of. No. Kakoti, there is a difference. A person who is connected with the Tezpur University is also the director of a private institute. This certificate is not given in the position of being connected with the Tezpur University, but by an institute which is private in nature. Yes, the contents of the same, of course, we are not ignoring. It has been stated that she represents the state of Assam in Hyderabad. Yes, so we pass a similar kind of an order.
We'll bring it on affidavit.
If vacancies are there, we'll consider her.
Yes,
Right now, you have the affidavit or whatever.
We'll file a
We'll give you some protection of consideration. First, B. Kakuti, Senate Council. for the petitioner also heard the big Kaushik, understanding of the elementary education department. Para. This court, by the order dated 17/5/2023, while granting time to the learned standing council to obtain instructions, had also made an observation that the prayer for interim protection would be considered on the next day. Three, Kaushik, the learned council, learned standing council, has obtained the instructions as per which, comma, the certificate annexed to the petition from which and on which the claim has been based are not in accordance with the requirement of the advertisement in question. Also, to be more specific, comma, the additional mark on cultural activities is granted only in the event a candidate represents the state, and in the present case, comma, there was no such certificate. On the other hand, comma, Sri Kakoti, the learned counsel for the petitioner, has submitted, and by referring to annexures 11 and 12 of the writ petition, has submitted that the petitioner is a renowned artist in the discipline of Odissi dance, and in the certificate dated 14/3/2023, comma, it has been stated that the petitioner had represented the state in Hyderabad in the year 2009. Full stop. As regards the fact that the certificate was issued by the Kasinath Krishna Priya Institute of Performing Arts, comma, the learned council has submitted that the director is also the head of the Chandra Prabha Saikyani Center for Women's Studies, Tezpur University. Full stop. Para. Whether the state certificate can be regarded as one to fall within the guidelines given in the advertisement is an issue which would require some deliberation. Issue notice of motion returnable by 4 weeks. 3. B. Kaushik, the learned for standing council
for both respondents.
Elementary education. What education? Elementary education.
Elementary.
Accept notice on behalf of the respondents. Let extra copies of the writ petition be served upon by tomorrow. Full stop. Third, the learned council on the interim prayer. Full stop. At this stage, Sri Kaushik, while opposing the state prayer, has also submitted that more vacancies are likely to come up apart from the vacancies mentioned in the advertisement. Full stop. Para. In that view of the matter, comma, though this court is not inclined to pass a blanket order of stay, comma, it is provided that depending on the outcome of the petition, comma, the case of the petitioner would be required to be considered in any ensuing vacancies as submitted by the learned standing council. And you try to gather more certificates. I don't think there is only one certificate. If you say your client is a renowned OBC artist, there will be definitely a state participation certificate. Bring those on record.
Second is
Similar, my lord, here the petitioner is a Bhavna artist, and therefore, my lord, again the committee constituted to verify the extracurricular activities has refused on the ground that there is no certificate which shows that she has officially represented the state in any national.
What is your certificate here?
I am a Bhavna artist. I have performed Assamese Bhavna in different languages of the
No, that is okay. But where is your state participation?
I have enclosed page 29. We have
29.
in Excerpt 14.
29.
This certificate was issued. It is an institution. They have performed all the cultural activities in collaboration with cultural department. And by this certificate, in the year of 2021, one Lipimoni Bora of the same district, Unitpur district, he has obtained. He was selected as an assistant. I have enclosed at place 60 and 61.
It's the same selection. Same selection.
Same selection. In the year of 2021, I have annexed.
No, 21 was the earlier selection.
Yes.
But what was the criteria, mode of
But the
selection?
certificate is same.
Certificate is okay, but what was the mode of granting marks in the earlier selection?
10 marks, same one.
And whether this certificate was the basis for granting or not, this.
I have enclosed at place, I come to place at 61.
Because this time, if the lordship will find my instruction placed earlier, there is a committee which has been constituted.
The earlier case, I think, is on a different footing. You have a better footing. Here we consider
Kindly come to place at 61.
61. 62.
61.
One.
I have annexes are 18.
Yes.
Here in the serial number 11, Lordship, Ipi Monipura, female, SC, kindly ECA mark, cultural 10 was added to her.
Okay,
She has placed.
Okay. First, but yes. Last 17, 5 for consider. Then what to be right? Yes. That's all I got like paragraph to go to. Three, Kaushik Dilana, Technical Council, Elementary Education Department, however, submit that the aspect of allotting marks for cultural activity is examined by a committee. He further submits that the certificate relied upon by the petitioner does not disclose that she has represented the state in any cultural activity. On the other hand, the counsel for the petitioner submits that based on a similar certificate, the candidate was selected and appointed on an earlier occasion.
Appointment, this is a provisional selection. Whether the final
Was provisionally selected on an earlier occasion. Also, Sarah, issue notice.
Selected.
She was appointed or not?
As per selection list, you know.
Have you made a? You have not been ever made that she was appointed.
Cannot be because this appointment is today, and this select list has published yesterday night.
Based on the same certificate, candidate, namely, a candidate, namely, Lipimoni Bora was provisionally selected in the same selection process. Yes. That there's no plan and the claim is based on, and the only basis is that a candidate was provisionally selected on this court is on the kind of yes.
This matter is related to completion of appointment.
Item number
31, Lordship.
Supply list.
Yes, sir.
There in 8/5/23, Lordship has passed an order directing the SPCID to file an affidavit bringing the report in respect of Jorhat on record. That has been filed.
You have already filed it?
Yes.
Got the copy?
Yes, Lordship. It's eliminated to Lordship. Regarding the date of application and some remarks column, the petitioner has manipulated Lordship. That is exactly his current affidavit Lordship. My affidavit Lordship.
You have filed a rejoinder?
Yes, Lordship.
You have filed rejoinder?
No,
Yes,
no,
Lordship.
no, no. Earlier he filed.
After this affidavit, I have not filed. The admitted fact, petitioner has admitted that he has done this mistake, Lordship. And for this, he has asked the apology, Lordship. And under circumstances, Lordship, actually, when DLC considered his case, when the matter came to the SLC rejected that he has not qualified. But he under impression that he applied after 11 years. That is why he corrected the date, Lordship. That is the admitted, Lordship, by an affidavit. So, Lordship, now, Lordship, only
Heard PSU Ahmed Learned Counsel for the petitioner. Also heard Sri Dina, the learned senior government advocate Assam, representing all the respondents.
No, here, CID I am appearing. Otherwise, the respondents are the education department. 1 and 2
senior government as well as Sri GPU for the elementary education department. Para we now the learned state council has submitted that an affidavit that pursuant to the order dated 8/5/2023, an affidavit has been filed by the Superintendent of Police, CID on 17/5/2023. The matter regards to a claim for consideration for appointment on compassionate grounds. The petitioner is aggrieved by the rejection of such claim. But however, from the affidavit in opposition, affidavit filed by the Superintendent of Police CID dated 17/5/2023, it revealed that the application was rejected as there was interpolation in the
I'm just facing the fact. He has approached the Honorable Court challenging the rejection by the SLC. And while filing the case, he has incorporated the DLC minutes in the petition. Finally, when we got the instruction, we found that the DLC minutes annexed by the petitioner is manipulated. Page 26 is the.
Then how was it considered by the SLC?
SLC, it was a recommendation by the DLC in a different. I'll just paste it. Kindly come to page 26 first, of the affidavit, recent affidavit.
Page.
Page 26 of the affidavit. Kindly मतलब annexure
Just a minute. 26. Page.
annexure A,
Page.
page 26 of the recent affidavit. Pull up. Pull it.
Yes.
Page 26. मतलब last column, serial number 12.
Yes.
Propository Gayan. This is the minute of the DLC annexed by the writ petitioner. The recommendation, kindly see the date of application 22/12/2004.
Yes.
And the recommendation that C is recommended for the post of LPS for the year 2000 LP for the year 2015-16.
Mm.
This is placed by him.
Mm.
Now kindly come to page 41. This is the minutes given by the deputy commissioner.
And that was considered by SLC law. This is the genuine lordship. Only
Page 41. The serial number 12.
12.
Third column, Propository Gayon is the applicant.
40, page
41. Page 41 is the relevant portion. Right? It starts at page 29. The relevant is page 41.
Nowadays, paginations are different. If continuous pagination, it's 50.
I'm sorry.
Doesn't matter. It's 12.
Serial number 12.
Not 12. 12 is, yes, 12.
12. Yes. First is his father name. Third column, Propository Gayon.
Correct.
Then the date of application, fifth column, 22/4/2015. Originally it is 15. He has made it 2004. Then the recommendation part he has manipulated. Recommendation says the committee observed that the applicant was minor at the time of death of government employee. Hence, he applied only after attaining the required age qualification. The case is forwarded to the government for consideration and recommended for the year of 2015-16 vacancy. Actually, this is not a recommendation for appointment. They have forwarded the case to the government, and this has been finally rejected by the SLC.
The SLC rejected might have not cut down lordship.
But this particular remark has been manipulated by the petitioner.
That is true, lordship. But the SLC which my friend shows lordship, serial number 12 does not is original, and on the basis of this lordship, SLC considered the case, but on other
One second. But at page 26, it was not a rejection.
Page 26 is the manipulated one. He is recommended for the post of LP.
Oh, this is the manipulated one.
Yes. This is the manipulated one. This has been relied while filing the writ.
It is manipulated. And now,
and while lordship has found that there is manipulation in the annexure, then lordship has directed the state CID to make an inquiry. And in that, the CID has intervened in the matter and submitted the inquiry report. Now, lordship has directed us to bring the report in respect of Jorhat district. Or
this is a serious matter.
Yes, lordship. That lordship petitioner has filed an affidavit. He admitted lordship, and now rejection was that on the basis of that lordship he has not qualified. He came with his writ petition praying for any other post lordship. When he filed the affidavit,
but you have introduced manipulated document in a writ proceeding.
That's he is asking for apology lordship. So I am my prayer lordship. So he is not pressing this matter lordship. That only he has done, and I filed the affidavit details.
We will not allow you to withdraw like this.
So maybe I have to dismiss with minimum cost lordship. With the 4%, I have filed the affidavit lordship. He admitted the fact lordship.
Not minimum cost.
Otherwise, if he came with the genuine DLC lordship, the SLC has considered his case, and SLC rejected on the grounded lordship. He did not have minimum qualification. Lordship, kindly see the SLC rejection. Lordship, kindly see SLC rejection.
Yes. Huh? No, first to proof. Such affidavit was directed to be filed in view of the submissions made and recorded by this court. Submissions made by Sri Nath, which was recorded in the order dated 8/5/2023, that the documents annexed to the writ petition was not telling with the official document. Full stop. That's the but remember, but the petitioner petitioner has based his claim on a so-called recommendation by the district level committee in which his date of application has been shown to be 22/12/2024, with a remark that remark of recommendation for the post of LP teacher.
Yes, sir.
LP teacher for the year 2015-16. You've seen there, she is there.
She.
Not he.
She.
The date recommendation is expected here in below, page 35. LP. Though the petitioner is a male candidate, in the recommendation, the reference is as he. From the affidavit filed by the Superintendent of Police CID, dated 17/5/2023, it however reveals that the petitioner, that there was no such minute and recommendation in favor of the petitioner.
Lordship, it is their lordship. It is in for the petitioner lordship.
No.
At least the
No such minute.
Well,
On the other hand,
minute is right lordship, but the date is
on the other hand, the official document containing the consideration of the case of the petitioner by the DLC would show that the application was not made on 22/12/2004, but on 22/4/2015. And the recommendation is to the following effect. Page 50. The aforesaid fact revealed in the affidavit in opposition along with the connected documents is however admitted by the petitioner, admitted by Sri Ahmed Learned Counsel for the petition. You have filed an affidavit?
yes, sir.
And has also filed an affidavit containing such admission. Sri Ahmed accordingly prays for a liberty to withdraw this matter. Though in ordinary circumstances, withdrawal of a writ petition is not refused, in the instant case it appears that fraud was taken recourse to by the petitioner in a court of equity, and which amounts to gross abuse of the process. Under those facts and circumstances, though this writ petition is allowed to be withdrawn, the same is subject to payment of cost of rupees 25,000 to be paid in favor of the lawyers benevolent for common Guwahati High Court Bar Association.
Maybe reduce the very proposal.
We have given less
Within a time frame.
cost you can execute, but not any time.
No.
Within 2 months.
Cost they have to execute, we are not giving time. Okay, make it 10,000. 10,000. Mr. Not 10,000, not 25,000. 10,000.
My lord, the petitioner before your lordship is an aspirant for the post of grade 4 post of laboratory BLS.
This is which item?
32,
Item
Lord.
32 supplementary.
Okay. People wish.
Yes, my
Yes, what is happening?
yes, my lord, the petitioner is an aspirant for a grade 4 post of laboratory BLS in the Archer Vidyapith College, Guwahati. And the advertisement was issued on 39/2022, and the call letter was issued on, my lord, wherein the written examination was held on 12/2/23 and viva voce test was held on 19/2/23. Thereafter, my lord, the governing body of the state college, my lord, published a selection list whereby resolution 4B reflects that in respect of the post to which the petitioner applied, a candidate who is having a BA degree, Bachelor of Arts degree, has been recommended for selection. And as your lordship knows, in grade 4 post, 8 or HSLC pass candidates can maximum apply, my lord. And
Yes, yes.
Lordship may have a look at the advertisement, Lordship, at page 25, Lordship. The education qualification is there, Lordship.
25.
Yes, Lordship. For grade 4 post, class 8 pass, Lordship. There is no higher limit set. So if the department gets a better candidate, Lordship, they can always select, Lordship. And moreover, this government body resolution, it was of 25/4/2000.
Where?
Lordship, at page 25, education qualification.
Top.
Yes.
The minimum
For-
was not there.
No, for grade 4 post, class 8 pass. That's it. So, Lordship, if we get a better candidate,
But the rules speak otherwise.
Where are the rules?
Lordship, the recommendation was of 25/4/2020.
No, Upamendo may be correct in stating that the advertisement has not, there is no violation of the advertisement.
No, but the
We can examine your matter.
Let notice be issued, Lordship.
I'll just bring home my point, my lord. My lord, these rules were notified on 5th of March 2022.
Applies to whom?
Advertisement was issued on.
Applies to whom?
Applies to all grade 4 posts. Lordship will kindly come to
Grade 4
rule.
post of what?
Lordship, I'm coming. Rule 3, my lord. Rule 3, Lordship, rules. These rules shall apply to all class 3 and 4 technical non-technical and class 4 posts under government of Assam. Am I clear, Lordship?
No, this post is of the college.
Yes, my lord. But it's a grade 4 post.
Grade 4 post, understood.
Yes, sir.
But are they
There are
deemed
no,
to be government servants?
yes, provincialized college. Once the institution is provincialized, they are brought under the.
No, there is control of the government, but are they government servants? But what about the advertisement? We have
Yes,
not
yes,
challenged the advertisement.
No, Lordship will kindly come. Lordship will see. Then rule 4, my lord.
We'll examine.
No, Lordship just one. Lordship will kindly please.
We'll examine.
Under the rules, my lord, there is a commission form for appointment of.
What is the stage now appointment done?
No, Lordship, and this recommendation was of 25/4/2023. Lordship, we are in 25/5, Lordship. More than 1 month has gone.
No,
What is
there
the stage?
My lord, as per my
It has only
instruction, today the ceremonial distribution is there of appointment letters. Today it may be handed over the appointment letter.
They could come earlier, Lordship.
No, this is of the college. Is it of the same
Yes, my lord. They are
same ambit?
that's
No.
my instruction, my
This is a different advertisement by the college.
true, my
This
lord.
is
But all grade 4 and grade 3 are covered by what is rules, my lord. And under the
No, no.
rules,
You said that in today's
that is my instruction. Lordship, can you just one page? I will just.
those are grade 3, grade 4 of the by the government. This is by the college.
yes, Lordship. Government body.
True,
Governing.
my lord. But the approval of the director of higher secondary is required, my lord.
Heard.
Lordship,
J.
one
Patwari.
more page, Lordship, last page. Lordship, under the rules, the commission has been formed for appointment of grade 4 post. Lordship will kindly come to pay.
For
Lordship,
commission
rules
for enrollment.
No, for appointment and selection of grade 3 and grade 4 posts, the commission has been envisaged under rule 4 of these rules.
Yes.
Now, my lord, kindly turn to page 35 of my read petition. Page
35.
35.
Yes.
This on the top, my lord, just below the emblem, state level recruitment commission for class 4 posts. Am I clear, my lord?
Yes.
First, you will kindly see, in exercise of power conferred under so-and-so act and the rules mentioned here in my lord, so-and-so, applications are invited for intending eligible candidates who are of citizens of India having registration number of employment exchange of the state of Assam for filling up 30,300 tentative vacant posts of class 4 under different department establishments of government of Assam in payment center. Educational qualification, serial number 2. Minimum qualification rate up to class 8 to HSLC 10 pass and maximum qualification HSLC class 8.
That's a different advertisement.
No, it's a the commission formed by the rules they are prescribing, my lord.
No, is it by the commission? Your
No. My appoint selection is by the government body of the college, but it has to be approved by the director of higher
No.
You may have a case, but I don't think the mistake.
My lord,
There is a distinction, Mr. Patwari.
I understand, my lord.
This is a commission is entirely for a different purpose. Then why did you participate? Why didn't you raise your voice?
No, Mullah, how can I know that BFAS will be selected, my lord?
No, no, how did you, why, you knew that it was not by the commission. If these rules are made for commission, how can you make these rules applicable to a recruitment by a governing body? It is not in against the advertisement.
No, it is not
If there is a policy not to give a appointment to persons who are more than higher secondary, that's a different matter. Whether that policy is applicable to a government college, that has to be
examined. Your lord,
examined.
yes.
But we're not say somebody is getting an
Then,
appointment.
my lord, kindly
J. Patwari, Learned
make
Counsel
the appointment subject to outcome of the report.
for the petitioner who is aggrieved by the selection made by the Arta Vidyapit College for the post of
Laboratory BRF.
laboratory grade 4.
Grade 4.
Grade 4.
Unreserved.
Unreserved. The categorical case of the petitioner is that for grade 4 post, the eligibility criteria is that the candidate should be class 8 pass and the maximum qualification should be higher secondary. Whereas the same case, the selected candidate, that's number 6, is a graduate and therefore was not even eligible for such consideration. The Learned Counsel has also referred to the Assam direct recruitment for class 3 and class 4 analogous post rules of 2022 as well as an advertisement as well as an advertisement that is 25/3/2022 by the
Page 35.
who is the issuing authority?
My lord, the chairman of that commission, that page is not there.
By the government,
By the
which envisages that direct recruitment for class 3 and class 4 would be done by a commission, and in the state advertisement, the maximum qualification for grade 4 has been stated to be HSLC within bracket class 12 or equivalent examination pass. On the other hand, Sri Upamanyu, the learned training council. This is higher education.
Yes, sir.
Higher education department submits that this writ petition has been filed on erroneous basis by referring to the advertisement in question, the standing council has submitted that it is the terms and conditions of the advertisement which would govern the recruitment process and which and the same were also accepted by the petitioner who had participated in the selection. As per the said advertisement, no maximum educational qualification was prescribed, and the only prescription regarding educational qualification is that a candidate should have passed the class 8 examination. Where is it?
Page 25.
25. A candidate should be class 8 pass. Class 8 pass. That issue, the issue involved may require some deliberation. Issue notice returnable by 4 weeks. 3 commenting the learned
1, 2, and
standing
3.
council accept notice on behalf of responsible 1, 2, and 3. Let extra copies be served upon him by tomorrow. Let steps be taken for service of notice upon the responsible 4, 5, and 6 by registered postal date. Steps by tomorrow. The learned council for the petitioner has prayed for an interim order. This court does not find a prima facie case for grant of an interim order staying the appointment process. However, it is made clear that any appointment made pursuant to selection shall be subject to the outcome of the deeply obliged.
Highly
Welcome.
May Petitioner. The petitioner is a chowkidar in the office of Deputy Inspector's office establishment. Now, the lordship will come. What has happened basically here is the petitioner has been serving for 23 years in that particular post as a casual employee. Now, the petitioner approaches Honorable Court based on a notification asking for minimum wages. Now, during the pendency of the writ petition, where there was an order that his case may be considered, there was no bar to consider his case for payment of minimum wages. Our impugn order has come, whereby my services have been discharged. So, if I may take your lordship to that court order and then to those orders of discharge.
Page
45. Page 44 is where it starts, WPC number 8342. And the order is at page 45. I'm just reading the last paragraph, page 46.
Pendency.
Pendency of the petition shall not be a bar for the respondent authorities to consider a petitioner for the amount entitled to him in terms of the decision in the case of Assam, which is Upendas. Now, in that particular case, the state government has given a sort of an undertaking that they will not going to terminate all these casual workers and master roles, and rather they will be paid the minimum wages. There is also a notification of the finance department whereby the minimum wage was fixed. We just claim that, your lordship. Due to the pendency of this petition, if your lordship will now come to page 56, the impugn order. Last page, your lordship, page 56.
Yes.
May I read it? Yes. This is by the Director Elementary Education. With reference to the subject cited above, I would like to inform you that Tonkeshwar Borua under Majuli district has filed a case before the Honorable High Court bearing WPC number 8342/2023 to extend the benefit of fixed minimum wages remuneration in the current post of night chowkidar in the office of the Deputy Inspector of Schools Majuli till his normal superannuation age. In the regards to parawise report as received from your end, by letter under reference, it is shown that the petitioner was temporarily engaged on daily basis in the office of DIS Majuli from 1 to 2000. So they admit about that fact. as per the order of the DIS Majuli dated 1/2/2019, 24/3/2020, and 2020. But no formal appointment letter was issued by the competent authority. The appointing authority is Director of Elementary Education Assam. Further, there is no government provision for any such private engagement by the officer. Therefore, such engagement done by the DIS Majuli is illegal and violation of the provisions of the government guidelines. So you are hereby asked as to how a private person was engaged in your office establishment by violating the government notification issued from time to time. You are also directed to take immediate stringent steps to release the private person from your office by issuing a speaking order as per the government rules and procedures. So the director even also says that you have to pass a speaking order, and that has to be in compliance of the government rules and regulations. Now, if you're lost, and it is also stated that the last line, the action taken reports should reach the directorate on and before 18/4/2023. Now, if your lordship will come to the preceding page 55, that is the impugn order. Now, we have categorically stated one thing, your lordship. This order is a backdated order and has been received by us only on 16/5. But just to meet that compliance of 18/4, he has put it as a backdate of 18/4 in this order. I'm just reading this order. As per letter received from the DE Assam, by letter such and such, Sri Tonkeswar Borua is hereby released from all the temporary engagement or at the office of the Deputy Inspector of Schools Majuli, and this order comes into force immediate effect. Now, this order suffers from infirmities that is very palpable in nature. Number one, the director's order, he is complying with the director's order. The director says, pass a speaking order. In my limited understanding, lordship, to pass a speaking order, the person against whom the order is to be passed must be heard. At least an opportunity has to be given to him. And a speaking order cannot be devoid of any reason. But this is not a speaking order. He is simply blindly saying, if the director has passed an order, I am complying with the order. The director has said, pass a speaking order. Has to be in compliance with the rules and regulations. So therefore, this order suffers from fatal infirmities, and therefore it can be set aside. And it speaks for itself. There is nothing that the government can do something to better up this order. So in my humble submission, lordship, I am still holding that particular post. No new person has been appointed therein. And this order is.
But how did you enter into the services?
Lordship,
how did you enter into the services?
2000 temporary appointment.
Daily basis.
Daily basis. I do not dispute that.
No, did the
continuous
person have the power to make such appointment?
Lordship knows that there has.
No, it's not a question of knowing. We have to balance equities.
Yes, lordship.
Your entry was not proper. It was illegally done.
Yes, I will not say illegal appointment, lordship, because there is no material or record to say it's an illegal appointment.
What is there where others given chance?
It can be a.
Was there by means of any selection?
No.
Why are you benefited?
I would say, lordship, it will be an irregular appointment, but cannot be directly termed as illegal, because that's
without
an inquiry.
Without a recruitment process, you are appointed. It's an irregular appointment. What is an irregular appointment?
And if a
suppose vacancies are more or less, you have been appointed in excess, those may be irregular. There is no recruitment process.
Casual employees, temporary.
We'll examine.
Now, if the lordship will see the appointment order, no, my lord, it has been marked to the director.
Maybe this director has taken some conscious step.
Lordship,
Today, without instructions, we are not going to.
I am on a different footing, lordship. The director order directly says pass a speaking order. This is not a speaking order, lordship. The impugn order is not a speaking order.
But what actions have you taken for minimum wages? That issue is still pending. We'll have this along with that.
My lord,
Creation.
Still that status quo may maintain.
no, my lord, no.
Because lordship has seen this order is illegal. My appointment is illegal. This order is also illegal, lordship. A speaking order cannot be devoid of any reason.
Will not pass any illegal order to revive something illegal.
I understand.
We'll examine. Heard creation concept for the petitioner. The petitioner claims to be working as a night jockey from the year 2020, 1 to 2020, 1 to 2000.
2000, yes. 23 years.
And was paid a fixed pay of ₹416 per month. The petitioner had approached this court earlier by filing a writ petition regarding his minimum wages, and this court in the state writ petition registered as WPC, so had made an observation that pendency shall not be a bar for consideration of the case for payment of wages, minimum wages, in terms of a decision of this court passed in a writ appeal in the WPC number 8342/2022. The learned counsel has submitted that instead of complying with the state direction, his services has been he has been released from his services by the Deputy Inspector of Schools, Majuli, Komolabari, by the dispute order dated 18/4/2023. It is the submission of the learned counsel for the petitioner that the impugned communication is based on an instruction by letter dated 5/3/2023 issued by the Director of Elementary Education. Full stop. While the correctness of the contents of the said letter is also questioned, the learned counsel submits that even the instructions have not been followed in the proper spirit as the same had required passing of a speaking order, which apparently has not been done. Para issue notice returnable by 4 weeks, 3 MSM and Sending Council, Elementary Education Department.
1 to 4 method.
Accept notice on behalf of respond numbers 1, 2, 4. 3. Sharma prays for an interim order. Full stop. While the entry of the petitioner into the services in the year 2000 does not appear to be one which is recognized by law, the aspect of his continuation for the last 22 years also cannot be ignored. In that view of the matter, it is observed that the interim consideration would be made on the next step. Fix. You have the instructions.
No.
Fix it on a particular date.
It have been done. It is 20, today is 20, 25.
25.
We will have it on 12. Not did you give the instruction. Two aspects, madam. First, you have taken action during the pendency of a petition. There is no bar. We are not saying because there is no interim direction.
Yes.
But minimum courtesy was to have a leave of this court, file your pleadings there. These are on different footing. It appears that the imputation has been taken only because he has come to the court.
Yes.
If you had not made the claim for minimum wages, this action was not forthcoming.
The director order is.
We are not putting a stamp of legitimacy on his appointment, but he was continuing for 22 years with his family. You cannot overlook all those aspects.
Monthly salary wage of 416 rupees only he was working. And now he has been.
You also take instruction regarding his performance, whether he was actually performing and to the satisfaction of the authority. Impugned order does not say that any misconduct was there on his part.
In fact, there are documents to show that he was, along with the other WPC laws.
Oh, list along with?
8342.
But when is that fixed?
There's no date.
List along with the
8342/2022.
8342/2022.
Obliged, Lord.
My lord, I am appearing for the respondent number 7, my lord. Some instruction was sought for my lord, but we need some more time, my lord, for instruction.
So Roy, this is a
Yes, my lord.
Your higher secondary,
Yes, yes.
yesterday we were looking for you. We knew that somebody was there for higher secondary.
Yes, my lord. But
2-3 matters. We had ultimately directed taking of steps by research post. We were aware somebody was there. We forgot you were there.
May I please,
But-
your lordship? My senior is in leg in court number
my
6.
lord,
Who is your senior?
MU Mahmood.
But this matter is the 15th.
my lord, we have entered appearance only on 8/5/2020.
When? Next week?
Yes.
Though this matter is of the year 2015, comma, Sri D.K. Roy, Standing Council, Assam Higher Secondary Education Council has submitted that he has entered appearance only recently, and therefore prays for some time to obtain the instructions of Sarah under those peculiar facts and circumstances, comma, matter stands adjourned to be listed on. We'll have it on not this of that. We'll have it on 7th of June. Enough time. Okay, Wednesday.
Yes.
7th June. 2 matters of what?
12 and 13.
Both the matters you are appearing?
Yes.
Well, good. Yes, next.
May I please your lordship? Lordship, can it be taken after some time, lordship?
What is this matter?
My lord, please, my lord, taking.
Here for whom?
I'm appearing on behalf of Mr. S.P. Sudri for Silchar NIT, National Institute of Technology.
And madam?
I'm the amicus student.
Amicus for whom?
Amicus not mentioned in the order as to for whom, lord.
For the
For
court.
the victim.
For the court. Or for the victim. Or for the institute.
Actually, my lord, there was some evidences which was placed by NIT. So while going through the evidences, the lordship had felt that there are some discrepancies. So amicus was appointed to point out those discrepancies. So that's how my amicus was.
I submitted a report in this regard.
You have submitted?
Lord.
Where is your report?
The seal cover report, lord.
Still cover report. Oh, reports are joint registered. We'll have it after some time. 19 matter. Can we take it up for disposal today?
My lord.
Then I call for the report. Joint registered. Have it after some time.
Obliged.
I have Mr. Chaudhary also. If not in the first half, then at 2 o'clock. Yes, next.
Teacher lordship.
Yes.
Also, the matter here pertains to seniority dispute with the petitioner and the private response.
In which establishment? Which establishment? In which establishment?
Lordship, in the
Working where? You're working where?
lordship, that is the school lordship. We are MB school lordship. Lordship, I'll take to page the impugn order. See that page 37.
There are 2 petitions.
Lordship.
Which are you referring?
Lordship, WPC number 321 of
The later petition, 321, page
page 37. Lordship, the
37. Yes. By the director? Yes, what has been stated? What is your name?
My name is Kamdev.
Okay, Kamdev. And your name?
I am private respondent.
Prasanna?
Yes.
A respondent number?
4.
R4. Okay, please read. Yes. No, please read the fact. Please read the entire thing. We'll know the facts.
13, the government method number 44 dated 14/11/2019, forwarding representation submitted by Sri Prasanna Chandra Das,
The aspect number 4 was the applicant.
Lordship.
Okay. Then,
And Peru's government letter numbers dated 26
okay. Next,
forwarding
content. You missed hearing. Missed it. That personative verifying the record. Scientific. Personative R4. Petitioner. The dispute is regarding insurance principle.
regarding the post of regular principal.
Regular principle. Prasanna Chandra Das. Specific graduate skill 1312. Date of birth 64. Joining specific qualification. Present skill 92. Senior. And it is seen that Kamdev Sharma is senior to Prasanna Das. Then
Senior Prasanna Chandra in terms of receiving graduate scale of pay, but his GH obtained from Bajata Thareli GH College, Bajata Thareli is not acceptable as there was no recognition by NCT in the name of Bajata Thareli GH College.
okay.
That is the case.
You are held to be senior, but your BA degree has been questioned.
The BA degree
Is BA a necessity?
got
Then what is your submission?
I have obtained in the year 96, and during that period, the application for recognition of the college was pending. NCT had stated that when the applications are pending during the period, those degrees are valid during the period of application. And they have clarified their standing.
Who has appeared for the NCT? Mr. Alam, you are for NCT. What is your stand? What is your stand?
We have filed our affidavit, my lord.
What have you stated?
They have filed their affidavit.
And in our affidavit,
Yes. Affidavit is not in the record. When did you file?
my lord, I filed it on 23/5.
23/5.
Yes.
Yesterday. The day before yesterday. What is your stand otherwise?
Otherwise, our stand is that the college have applied on time within the extended period, my lord, 18/8/1997. So it is a valid document.
Okay.
Let the affidavit may come.
May please your lordship, that thing is in order. The petitioner was appointed in 1998.
Correct.
As in Guya MP school. Thereafter, he was transferred to the Borka ME school.
Yes.
And Borka ME school amalgamated with Borka High School. I am since the appointment, I am working in Borka High School. The petitioner comes in my school by transferring. Subsequently, his school amalgamated with my school. I am working.
Now, was the transfer at the request of the petitioner?
Lordship.
The transfer or the amalgamation was where those situations or events done at the influence or instance of the petitioner?
Yes.
Can she be held responsible for an amalgamation or a transfer? Was it done at his instance?
Yes, but amalgamation notification.
The amalgamation is a policy decision. You cannot attribute fault of the petitioner. Your only issue is regarding the transfer. Was it done at the request of the petitioner or was it done in the public interest? If it is done in the public interest, will he lose his seniority?
Yes. Another ground is that as per amalgamation notification, there are some guidelines. As per page number 16 of my amalgamation order notification, clause 4 prescribed.
Now, we have to examine the validity of the impugned order. The impugned order has been passed on only one consideration, that the BA degree is not valid.
Yes.
Now, if the NIT, the authority who confers or who is the authority to have the final word on the validity of such BA degree, if they are expressed that is in favor of the petitioner, we cannot go, or there is no occasion for us to go to any other consideration. You have not challenged this order, the first part, saying that Kamdev Sharma, who is the petitioner, is senior to you. The order by which her claim has been rejected is only on the ground that the BA degree is not recognized.
Yes.
Now, the authority who has the power to has said that the BA degree is valid.
Yes.
In absence of any independent challenge by you regarding the finding that the petitioner is senior to you, on your plea as a respondent, we are not going to adjudicate. You have to file a fresh petition. Unless you raise this issue as a petitioner, we are not going to enter into those aspects. Let this petition, this affidavit come on record. We'll pass.
In fact, my lord, one thing, my lord. In fact, the Honorable High Court, Honorable Division Bench already decided that issue, my lord. In retable number 154 of 2022, my lord, which was judgment delivered on 28/4/2000.
Which issue?
In Pawan Kumar Sinha versus State of Assam.
Which issue?
That issue, my lord, regarding the extension period and application submitted by the
Okay.
respective.
Your decision has been upheld.
Yes, my lord. The Salana Singulja judgment has been upheld.
No, your decision that
Yes, my lord,
the
yes.
period is valid, that has been endorsed by the division bench.
Yes. And I will place it for your lordship next week.
We'll have it on. Let the affidavit come. Okay. Next Tuesday. We'll dispose this of. Heard MS 8 adopt the Learned Council for the petitioner. Also heard who is you Sharma, Learned Standing Council, Higher Education, Secondary Education Department. Whereas I Alam has appeared for the NCT. Your name, your Burman.
Yes, Burman.
As Burman has appeared for the phone number 6.
4.
Phone number 4. Full stop. It transpires that the response number 8 dash National Council of Teacher Education has filed an affidavit on 17/5/2023, which, however, is not with the record.
Sorry, my lord, that is 5 on 23/5/2000. It is acknowledgement.
This, you have given the date 17/5.
Subsequently filed it, my lord, on 23rd of
Filed on 23/5/2023, which is not tagged with the record. Full stop. Sri Alam, however, submits that the BA degree of the petitioner is considered to be valid in view of the fact that the approval was sought for by the college in question within the prescribed period, and such a decision is also endorsed by judicial pronouncement of this court. Full stop. Para. Be that as it may, comma, since the affidavit of the LCP is not in record, comma, matters is adjourned to be listed for consideration on 30th of May 2023, by which date, comma, the office would tag the affidavit of the response number 8 with the case record.
Send it to my lord on after.
First,
Yes, my lord, I have other.
first of the next Thursday. You take this back. Your copy.
That's okay.
Mr. Borman, you go through the affidavit of the NCT. That will play a major role, and you try to defend your case.
on judgment of the Supreme Court 2029 of 2016.
Yes.
May it please your Lordship. It's a very narrow campus the matter is, my lord.
Yes.
My lord, all these petitioners before your lordship, these are petition, my lord. There are 3 petitioners in this case.
Hmm.
3 petitioners in this case. And my lord, there was an advertisement by a notice board in the GIST, that means Jorhat Institute of Science and Technology, on 18/6/2016. It was not published in a newspaper, but it was hanged in a notice board.
18/6.
18/6/2016. First advertisement. There was a different post which they advertised at page 23, my lord. Side by side, your lordship can look into it at page 23. 18/6/2016.
Sir, you're appearing for whom?
I am for technical higher education department.
We take up for final disposal?
Yes, yes. All is my lord, number of time. My lord.
How many matters? One matter?
Only one, man. It does not take much time. It is very narrow campus.
23.
18/6/2016.
Page?
Page 23.
It is okay.
Lordship got it?
Yes, yes.
Now these are the post. Name of the post, education qualification, number of post. We are concerned about 234, my lord. 234.
Yes.
Now, my lord, here when it was advertised, no applicant was there. So they have to re-advertise, my lord, at page 24. 28/10/2016. Kindly turn to next page, my 24. This is the 28/10. They advertised, my lord. Last date of submission application 15/11.
Again in the notice board.
Yes, it is by the principal. Principal.
Yes.
Now, my lord, at page, they constitute a committee, and accordingly at page 26, different orders were passed. Page 26, kindly see, my lord.
Yes.
29/5/2017, as per the approval of the Director of Technical Education Assam, the undersigned is pleased to appoint as section officer of GIST on contract.
This is petition number 1.
Yes, petition number 1.
Appointment.
Appointment on contract.
Person to decide advertisement.
Yes, on contractual. Bracket, my lord, on contract.
Yes.
And hereby assign the duty in the GIST examination cell for smooth conduct of all kind of examination at GIST, maintaining quality in all respect, keeping confidential records, so and so, so and so. Now, my lord, at page 27,
yes,
this is another appointment of petition number 2.
Understood.
Lord,
Same date.
And same date.
Yes.
And next, your lordship will kindly see at page 29. This is petition number 3. 29.
Same date?
Same date. It is 29/5/2017. It is not legible.
It is page 28.
28, 29.
29, 5,
Time
same
copy here.
date.
Same. So all these appointments are being made.
All a section officer.
Yes. He is a computer. He is a computer operator.
Petition number 1 is the section officer.
Yes. Number
2 is
2 is, my lord, the section assistant.
Office assistant.
Office assistant.
2 office assistant.
And third is 29 is the computer operator.
Yes.
Number 2, 3 judges. 29, my lord. Lordship got it? All
Yes,
these
yes.
3 appointments?
Yes, yes.
Now, my lord, this was at page 22.
22.
22. I'll just one page. First page I'll show it, my lord. Lordship got it?
Yes.
This is 1811. This is for food conduct of all kind of, my lord, examination. They constitute examination at GIST. So this first P45, their name appears. Kindly see, my lord. P45. Got it? P45.
Yes.
So what they have to do it, my lord, their functions, my lord, it has been mentioned in this office order. For smooth conduct of all kind of examination at GIST, maintaining quality in all respects, keeping records in full confidential custody through proper filing. The cell is responsible to carry out continuous evaluation process as per AICT affiliated university guidelines. Cell is also responsible to develop innovative ideas to reform the examination center time to time to achieve the goal of the system.
Yes.
So, but there was
Petitioners were included in the examination
Yes.
cell.
So there were requirement
Yes.
of them to fill up. So they fill up by putting it in a notice board, and accordingly they appeared, and ultimately they were included in this team. Now, my lord, will kindly see.
But tell us one thing.
Yes.
Your appointment
Yes.
was in May 17th.
Yes.
And then in the examination cell, how
I have seen that, my lord.
how could you be
Yes.
included in the examination cell,
I
which was of
think there
16?
is some mistake. I don't know, but this appointment is 2017.
17 and
Yes.
18, 11, 16,
Yes.
you are already inducted in the examination cell.
Correct, my lord.
And you have
Right.
been already designated as UDA, LDA.
Right, my lord. Lordship is right.
There is one more line here.
Yes.
In pursuance to pending approval by the Director of Technical Education.
Yes.
What has happened to that aspect?
The approval was given by Lord, will kindly see at page 26. As per the approval, they were appointed, but as per the approval.
No, this is not. We are not on the appointment order.
What you
Here is page 22.
50.
Page 22.
22.
The constitution of the examination cell.
Yes.
Which had included the 3 petitioners.
Yes.
If you read the first line.
Yes.
In pursuance to pending approval of the Director of Technical Education.
Yes.
That means this examination cell constitution needs to be approved by the Director of Technical Education. I think that approval order would throw some light on the date, anomaly with the date.
Which approval, my lord? I have not followed. In pursuance of the pending approval.
Pending approval of the director. That means the director needs to approve this constitution of the examination cell.
What I feel, they have to give an answer to it. Maybe, my lord, there was an advertisement which has taken place on 28/10/2016. Immediately on the basis of the advertisement, my lord, I think there was appointment which was made on 18/11. Thereafter, the approval was given later on. Pending approval. Kindly see in persons of pending approval.
No. Pending approval is only for the constitution of the examination cell, not for the appointment.
But I think this approval was given by director. Maybe there was appointment and thereafter the approval was given.
See, this office order of 18/11/2016 at page 22 is not pertaining to any appointment.
No, this is not
it is only a constitution of an examination cell.
Correct.
And that constitution is required to be approved by the director.
Right.
So the first line is that pending approval. That means there will be a post facto approval by the director. That post facto approval may provide some light on in resolving the anomaly, because your appointment seems to be of a later date.
True. Appointment is 2017.
Okay. You proceed.
Yes. Now, my lord, thereafter, my lord, there was at page 31. Kindly see page 31.
Yes.
22nd of January 2019.
page 31.
One.
Yes, please.
Following the instruction of Honorable Director of Technical in Assam during her kind visit to his institute in the month of December 2018, undersigned is pleased to constitute a selection cum training committee with the following members to verify the testimonial, other relevant document and the performance of the employee of this examination cell established with due approval of the Director of Technical Education Assam for onward transmission of the proposal for regulation of the services of the employees appointed on contract basis again sanctioned vacant post. So this screening committee was constituted, my 1, 2, 3, my.
Yes.
Now, at page 32, proceeding of the selection cum screening committee. At page 32.
Yes.
25th of February 2019.
Yes.
Yes. They said on 25th of first line, 25th of February 2019. These are the 3% where screening committee constituted. Resolution 1. The selection cum screening committee is pleased to recommend highly the names of the following employees to regulate the services in the interest of public. Committee also authorized the principal GIS to submit a proposal to the concerned department for necessary disposal of the matter for the greater interest of the institute. So these are 1, 2, 3. They were recommended.
You are the petitioners here.
Yeah, these are petitioner who contractually who was appointed. Screening committee was constituted, and on the basis of the screening committee constituted, recommendation was made, and on the basis of that, my lord, at page 38, my lord, 38.
38.
38.
Yes.
27, 2019. On recommendation of the selection committee and the proposal submitted by the principal, gist and observing satisfactory services, interest of public, undersigned is pleased to appoint the following contractual employees of GIST who have been extending.
Where do you get the date?
Page 38.
Where do you get the
down
date?
below, my lord, dated 20/07/2019. Director.
Yes.
On the down below.
Yes. Yes. Yes.
These are the, my lord, so and so, since very inception of so and so. Scale of pay of post is shown below the name, so and so, so and so. Lordship got it, my lord?
This is regular appointment.
Yes.
Yes.
Then, my lord, they worked and they got the salary for 3 months. 3 months salary was given.
Yes.
Now, my lord, will kindly one thing. At page 34, 33, 33.
Yes.
33, principal has written to the Director Technical Education at page 33. Furnishing details of contractual staff employment examination cell for approval.
Yes.
With reference to subject, I have the honor to furnish here detail of contractual staff examination cell duly filled in a format given from esteem office. In this respect, I would like to inform these employees were appointed approval of so and so. Employees are found sincere and honest in duties. Noted the employees have been extended services since very inception examination cell against a small amount arranged from the student fees collected during the time of admission. No budgetary provision is made till date from the government. Please find the same. Provide necessary instruction, disburse the salary to Jorhat Treasury from the budgetary provision against the sanctioned vacant post as other contractual employees of the government of Assam. Now at page 34,
yes.
19th of December, my lord, the Undersecretary has written to the Accountant General, kindly see, my lord, I am directed to convey the sanction of the Governor to direct creation of 23 number of teaching, non-teaching posts of Jorhat Institute of Science and Technology, Jorhat, in the scale of pay shown against each plus other elements as admission under rule with effect date of so and so. Now, if your lordship kindly see 5, junior assistant 6 number post, 6. 7 is Najir is 1 post. Lordship got it. Kindly note these 2 posts, my lord. 5 and 6. So this was now at page 36, my lord. Kindly
Junior
see at-
assistant is 6 posts.
Yes,
Nazir,
Nazir is 1.
why Nazir is required?
Now that's why, my lord. 36, kindly see, my lord. Kindly see 36.
Yes.
Detail of contractual non-teaching employee appointed against sanctioned vacant post to run the academic admission program smoothly. Sanction strength 23, lot you got it. Man in position 11, regular. Man in position 3. So on Ajanta Ratta petitioner number 1, Nazir name of the post redesignated as section officer. Original sanction order is so and so, date of joining, mode of selection, walk-in the selection board authority, institutional screening committee. Following the approval of DT, this appointment was made to establish the examination cell at so and so. Has to be conduct 32 different so and so examination in an academic session under 2 universities so and so. Now 2 is my lord Vidyarthi Bora junior assistant so and so. Third is Nobodita Bothakur, junior assistant computer operator. So this was Nazir redesignated. So that was at page 37. Kindly see page 37.
Yes.
Director to the principal. With reference, the undersigned pleased to provide approval to the proposal submitted by esteemed office. Following posts are renamed to incorporate the system without prejudice all service condition or the post designed at the time of original sanction as stated above. So Nazir is sectional officer, original post, redesignated, what you got it. And number 2, junior assistant is office assistant, 3 junior assistant computer operator.
Yes.
So the scale of pay has been mentioned, my lord.
Yes.
So this way, my lord, at page 38, my lord, they were regularized in their service. 3 months salary they paid. Thereafter, the government stopped paying salary.
After 3 months.
After 3 months. So they have written at page 39, 28th of January 2020, request to release their regular monthly salary.
Where?
At page 39 is a type copy and the main has paid 40.
21.
39.
No, 20,
Yes, 20th
20th
January 2000.
representation.
Yes.
For release of salary.
Salary.
Okay.
Lordship, they have not received any salary. Then there was, my lord, now the problem started. The director, who's one Mosami, he then director. Then a letter was written by the joint secretary director, which your lordship will kindly see at page 41. Page 41.
41.
Yes. 5th of March 2020. This is a problem where you started. 41. Secretary to the government of Assam written to the Mosami Barua to so and so, Professor Department of so and so. He was, my lord, D then, Director Technical. My lord, your lordship, remember, he has approved, appointment was being made, approval was given by her. So now, there was a letter which was written by the secretary addressing to her, subject kindly see, clarification regarding appointment of 3%. With reference to subjects that you are hereby clarify on the following post points. The letter number dated 26/3/2019 issued by you during your tenure as in charge director of technical education. Reason for changing nomenclature of the original sanction post as internal arrangement. So letter number so and so, reason for issuing appointment letter for 3% for different posts in the same date, matter may be treated as very urgent. So this letter was written, my lord. So there was some letter which was written to the government. Now, my lord, all this went internal communication.
This particular lady was the
D10 director.
Director.
Yeah, D10.
Of the Jorhat.
Director technical education. Director technical education. These are all under director technical education. Higher technical department. Higher education,
Director.
bracket technical department.
Yes. We'll continue.
Yes.
Now what has happened?
No, last page I will show, my lord. Then thereafter, my lord, at page 47, 24/6/2021, my services was terminated. On 24/6/2021. In compliance with the government order dated 22nd of June 2020, service of following person in so and so sector hereby terminated with immediate effect on the ground of gross irregularity made with appointment them on regular basis. Dated so and so by Dr. Mosai Barua, deed and direct. So this 24/6/2021, my lord, an order was issued to us basis of an order that has been passed by government on 22nd of June 2021. I have that, my lord. We have annexed them. So they have terminated without giving any so cause to us. Directly because it was done by deed and the technical director. So that is the ground, my lord. We have been terminated.
What do you say?
I will reply, lord.
No, we'll hear you elaborately. At least on the notice part.
Notice is not required, Lord. This is a fake appointment. The particular file is also non-existent in our office, Lordship. I hold the record, Lord.
Then constitution of the committee.
Lordship, the very appointment, this appointment that by which letter directors approved, Lordship, it is a fake appointment letter, Lordship, and it was not a fake approval order, and that file is also not an existent file, Lordship. I have all the records, Lordship.
This particular director at that time did not give approval.
Lordship, Lord.
Where from this document came?
Lordship, I have all the original records, Lordship. On the basis of the records, I am submitting, Lord.
Yes.
Is the IL or in this case, a petition has been filed in 2019, challenging a office memorandum, and by virtue of office memorandum, court has given interim protection, meaning that you can appear. Petitioner may be allowed to apply for the advertised post, and but the result will be outcome. Any candidature and selection will be outcome of the district. Then, Lordship, I appeared, and I have been selected for a particular post in the ADP college autonomy. Then, the time I was overage on 2 months 17 days. I applied for them for that application, and after selection, that was not done. So I have filed another writ petition, that is 2725 for condoning the overage. During the pendency of the writ petition 2725, my overage has been condoned by the government with cabinet decision on in my IL page number 12.
13 February.
Yes, sir. 2020.
Yes.
So I have filed this IL to there is an interim order, there is a observation from this court that the outcome and selection. So I have my appointment has not issued to me today.
We cannot pass the direction. We can say that there is no bar for considering.
Yes, that much.
Regarding that part, I have no objection as cabinet has taken decision, Lordship. Above the cabinet, I cannot say anything, Lordship. Otherwise, law is well settled, Lordship. Cabinet has taken decision, we have no objection.
Lordship.
30, there was no representation before the authority, Lordship.
30, what is 30? Different case.
For 30 different, but there was also no date for the last date of publication of form. But by an order of court, the petitioner was allowed to appear in the selection process.
What is 29?
29, my lord, the
Original
office.
As per the direction of the petition in 29, Lord.
Now, what is your name? Nirmala Devi.
Nirmala.
And in 29, the petitioner is somebody else.
My lord, what happened, my lord, in 29, the petitioner delayed the office memorandum of 2018, wherein the guidelines were formulated by the state government for appointment and selection of professors.
Now, the IA is before us. We'll pass orders on the IA. repetitions will consider when it heard Sri D. Mahanta, Senate Counsel for the applicant writ petitioner. Also heard Sri K. Gogoi, Standing Counsel, Higher Education Department, whereas along with the Bukolial, the learned State Council. And revenue is also there. Anybody revenue department? Yes.
Finance will be there in revenue. Revenue, long list. Revenue is not a party here, Lord.
Why SC revenue is being shown?
SC revenue.
Mr. Rahman, you are for whom? Who's 6?
My lord, college.
College. Sri H. Rahman has appeared for the responsible 6 college. Responsible 6 principal of the college in question. Put up by this I, comma, interim directions has been sought for issuing sought for issuing appointment letter to the applicant by the respondent 5, that is the Director of Higher Education, Assam. Put up there. Sri Mahanta, the learned counsel for the applicant petitioner, has submitted that in the writ petition, in the connected writ petition, comma, there is an order providing that candidature and selection, if any, would be subject to the result of the petition. Full stop. The learned counsel has also drawn the attention of this court to an order dated 13, to a notification dated 13/2/2023, issued by the Higher Education Department, whereby it has been conveyed that the overage of the petitioner has been condoned. Full stop. Sri Mahanta accordingly praised for a direction for the aforesaid direction as referred above.
Island may also indicate we have original record that cabinet is some before
for direction aforesaid for direction referred above. Full stop. Sri K. Gogoi, the learned standing counsel, has fairly endorsed the submission of the learned counsel for the applicant. Also, however, he submits that instead of passing a direction for appointment, comma, it would be in the interest of justice that the direction should be clarifying that there is no bar for such appointment. He has also praised for this court the cabinet decision regarding the relaxation of the age of the petitioner in question, of the applicant in question. In view of the aforesaid facts and circumstances, comma, this court is of the opinion that an interim direction is warranted in this case in view of the subsequent development. Accordingly, it is directed that, accordingly, it is observed that there is no bar in consideration of the case of the petitioner in view of the fact that her age has also been condoned for appointment to the post of assistant professor in the ADP college, Nagaon.
By the cabinet decision.
We have said the para, the I according to sense disposal. The cabinet decision to date to deliver. Cabinet decision dated 23/1/2023.
Date may be fixed.
In the writ petitions you write, pleadings are over.
They have not filed with the come up with everything. But
In the rest of the matters, list after 3 weeks, by which time the affidavit in opposition by the contesting respondents may be filed. Yes. Correct. You take this back. Report to it. Report was directed to be given in a seal cover. Fifteen. Seal cover. We'll do one thing, madam. We'll go through this report and we'll take a call whether this report should be furnished to the relevant.
That report was already furnished. Both the parties.
Furnished to you?
Yes.
Okay. But we have not gone through the report. What is it said?
In fact,
Madam, what have you said? Now that's it, we have understood. What is your finding? Now, what is the what are the parameters which are being followed by a committee?
My lord,
Editor, workplace
submit, my
sexual
lord.
harassment of women.
Lord,
Workplace.
after that Dhaka judgment, my lord, another judgment was there, which says that it should be incorporated in service. Person
No,
to
that is the part of the
my
statute.
lord, now person to
I think section 3, 4.
rules has been amended,
Yes.
incorporating that part as a part of it amounts to misconduct.
No, we are not on that. What is the prescription? What is the procedure
Procedure is
which is to be followed in terms of preliminary inquiry?
laid down, my lord, in
I think in 4,
Rule 7 is the
7.
of the sexual harassment rules, my lord.
Seven of rules.
Rules, my lord.
Of the rule. No, we have principles of natural justice. In conducting an inquiry, the minimum of 3 members. 3 members were not there. How many members? No. One person. In fact, that will be a violation of 4 also. Constitution of the
I
Internal.
am alleging violation of 4
No. 4 of the Act.
of the Act.
Internal committee shall consist of the following members to be nominated by the employer. Presiding officer, who shall be a woman employed at so and so. Number B, not less than 2 members from amongst the employees preferably committed so and so. And 1 member from amongst non-government. At least 3. And which has been clarified by the rule. And there was one more provision which refers to the concerned service rule. Where is it? Which provision? Madam Chakraborty?
My lord.
There is one more provision which refers to the concerned service rule. Yes. No. In the Act itself.
My lord, section 9 is the complaint, my lord.
9.
9.
Okay. Yes. 11.
11 is the inquiry into the complaint.
11. Subject to the provision, section 11. Subject to the provision of section 10. The internal committee or the local committee, as the case may be, shall, where the respondent is an employee. Here is an employee, you are an employee. proceed to make inquiry into the complaint in accordance with the provisions of the service rules applicable to the respondent. CCS rules have to be followed. That part has been clarified that principles of natural justice is required to be there. What do you say, Mr. Chaudhary? We are not on the merits of the allegation.
Yes, sir.
We can make it clear. We are only on the procedural part, and that is the part which our subject matter of a judicial review.
Because Lordship, in the repetition at paragraph number 5, the constitution of the
Now you have you are the custodian. You know the record.
Yes.
Was the proceeding held behind the back of the petition?
It's not like that, Lordship. In the affidavit also we have clarified that aspect of the matter. This is the basic allegation in the repetition. So we have responded to that with regard to the fact that it was given.
Now the evidence were directed to be looked into by an amicus. Report has been given.
Yes.
It says that the evidence appears to be done without giving him a chance of cross-examination. Number one, were the principles of natural justice followed in the inquiry? We just want you to be fair and transparent.
Yes, Lord.
Without making any comment on the merit.
Exactly, Lord. Exactly.
Because see, even if we interfere, we are not saying anything on the merit. We can remand it back. But we need a fair stand from you. What is the procedure? Whether the allegations regarding procedural irregularity or infirmity are those correct? In fact, we also take assistance of the learned amicus.
With regard to this,
Paragraph 11 says that documents that they have never been supplied with CCTV footage, nor the documents relied against him, the statements of the witness recorded during the proceedings had never been afforded never been given to him, and never been afforded any opportunity to cross-examine any of the witness, if at all, against him. He is
And mainly
completely
the constitution of the committee. That's the fundamental issue. Jurisdiction.
and with regard to that particular paragraph, Lordship, we have responded in paragraph number 50. And where we have,
we may not be strictly confined to the pleading.
yes, sir.
Does the record suggest that the committee was properly constituted? How many members?
Deciding officer, MD member,
Which is the document, Chakraborty, in the writ petition regarding the committee wherein we can
paragraph number 5. 36.
Yes. But your paragraph 5 refers to at least 7 members. Where is the valid?
And it is there, Lord.
Paragraph 5.
In paragraph page number 36 also it is there.
So why are you saying that there is a violation of the constitution part? No, that part is only regarding constitution of the committee. 36. 36 is a 7-member committee. Okay, you mean to say that though the committee was there, effectively those were not there. The committee, if you read 7, the meaning which can be inferred is that though the committee may have more than 3 or 4 members, 5 members, but at least 3 of those are required to be present when the case is conducted. See 7 rule. It doesn't say about the committee being constituted of minimum 3 members. It says in conducting the inquiry, a minimum of 3 members of the complaints committee. That means committee has to be of more than 3 members.
Including the presiding
If it is
officer?
more than 3 members, at least 3 have to be there.
Yes.
Including the president officer or the chairperson, as the case shall be present.
Yes.
It may not be necessary for all the members to be present, but 3 minimum are required to be present, including the president officer or the chairperson. Now, how many were there during the that will which year?
The signature is there. The evidence is there.
That in my reply also I have stated this, that only one member was present and all these statements were recorded.
No, signature, sir. Then where from you have got it?
Chaudhary, what are the allegations? Serious allegations?
Lordship, kindly see the evidence because on the last occasion.
No, what are the allegations?
Because my learned friend has brought to the notice of this honorable court.
Date.
Page 25.
55.
Hmm? 20. Initiate proceeding immediately. The complaint.
I think we will remand back. The instant writ petition has been filed challenging a proceeding initiated under the sexual harassment of women at workplace within bracket prevention, prohibition and redressal bracket close act, 2013. Full stop. The petitioner has put to challenge in particular the report dated the report of the Internal Complaints Committee dated 29/5/2019 and 27/9/2019 and the subsequent show cause notice dated 21/10/2019 issued on the basis of such report. Full stop. Before going to the issue which has arisen for adjudication, the basic facts of the case may be narrated in the following manner. The petitioner is an assistant professor of grade 2 in the Department of Electrical Engineering at level 10 of the pay matrix and was on probation at the NIT Center. Full stop. It appears that the case projected is that a complaint was lodged against him by a student alleging harassment. Full stop. Based on the same complaint, under the Act. Under the Act in question, an internal complaint committee was constituted. Dated 10/10/2018. An internal complaint committee was constituted to inquire into the matter. The committee, the internal complaint committee within bracket hearing of ICC. The ICC accordingly made an inquiry and had furnished a report on 29/5/2019, correct? Which was followed by a final report dated 27/9/2019. Full stop. 27/9/2019. Full stop. Being agreed by such report, the petitioner had also submitted a representation dated 14/10/2019. Full stop. However, the representation was rejected and a show cause notice dated 22/10/2019 was issued. The petitioner had also submitted reply on 25/10/2019 to the same show cause notice. Full stop. The petitioner has challenged has based the present challenge on gross violation of the procedure laid down in the Act and also has alleged violation of the principles of natural justice. Full stop. I have heard MSP Chakraborty, Senate counsel for the petitioner. Full stop. I have also heard Sri Chaudhary for NIT, SP Chaudhary, standing counsel. Yes. Standing counsel for the NIT Silchar. Full stop. This court, correct. This court had also appointed the paragraph. I have also heard MS D. Saikya, London Council, acting as a amicus, who was appointed by this court by an order dated. What is the order, madam? 1511. 1511, 2022. Pursuant to which, comma, the learned amicus has also submitted a report in still cover after going through the evidence recorded by the ICC. The said report on a query by this court, it transpires that copies of the same report were subsequently furnished to the learned counsel for the contesting parties. Parties. So the report furnished by the learned amicus has been carefully examined along with the evidence which are also placed before this court. MS Chakraborty, the learned counsel for the petitioner, has submitted that even without going into the merit of the veracity of the concern, has submitted that the allegations made against the petitioner are absolutely incorrect and figments of imagination. He, however, submits that even without going into the veracity of such allegations at this stage, the procedure adopted is wholly against the mandate of the Act. Reference has been made to the provision of Section 4, Section 4,
Rule 7.
and 11 of the Act. Reference is also made to Rule 7 within bracket 4 and 7.7, right?
Yes.
7.7 of the rules rules for equilibrium. So rules within bracket here in after call the rule. Full stop. That apart, it is submitted that the learned counsel for the petitioner has submitted that though the constitution of the ICC appears to have been done in consonance with the requirement of Section 4, the inquiry, the evidence were adduced in gross violation of the provisions connected to such constitution of the ICC. Referring to the provisions of Rule 7 within bracket 7, the learned counsel submits that in the inquiry, a minimum of 3 members of the complaints committee, including the president officer or the chairperson, is required to be present. Full stop. However, in the said case, the evidence was recorded only by the president of the committee, right?
So records speak otherwise. The signature of all the members are there.
Okay, her allegation.
Yes. No, we have specified that there is no violation of the rules in the procedure. So we have covered up the entire aspect of that.
Reference has also been made to the requirement of adhering to the principles of natural justice, which has been laid down in Rule 7 within bracket 4. Full stop. He submits that the evidence was recorded behind the back of the petitioner without giving him any opportunity to cross-examine the witness. Full stop. It is further been alleged that none of the documents connected to the allegation has been furnished to the petitioner, and therefore the petitioner was deprived of an effective opportunity to make a reply. Full stop. The Senate Council accordingly submits that the basis of the so-called notice, which are the reports of the ICC being without jurisdiction, the departmental proceeding which has been initiated cannot withstand, cannot be held to be to have the legal sanction. Full stop. The Learned Council has also referred to section 11 of the Act, which requires that an inquiry made by the ICC is to be done in accordance with the provisions of the service rules applicable. And in the instant case, those are the CCS rules. Full stop. It is submitted that the provisions of the state rules have not been followed, and therefore the entire proceeding initiated against the petitioner is liable to be interfered with. Full stop. Per contra, Sri Chaudhary, Learned Counsel for the NIT, has submitted that the allegations made by the petitioner does not appear to be correct. Allegations do not appear to be correct. He submits that the ICC was constituted. No, submits that constitution of the ICC was strictly in accordance with section 4 of the Act, and there is no violation. Sri Chaudhary also refutes the allegation that there was violation of the principles of natural justice, and also the allegation that the evidence was recorded only by one member. He submits that the proceeding would reveal that it was signed by all the members and all the members.
In their opposition, they have stated when a prima facie case was made out, further disciplinary proceedings have been initiated after prescribed procedure. This further stated the inquiry conducted by ICC is a fact finding with regard to the allegation, not allowing the petitioner to cross-examine the witness same would not anyway violate the principle.
We'll come to it. We'll come to it. We're recording his submission. Sri Chaudhary accordingly submits that the allegation of violation of the Act and Act provisions of the Act and the rule are unfounded, and therefore there is no ground for interference by this court. Anastasia Delane Amicus, by referring to her report dated what is the date, madam? Madam, you have not even signed the report. Date is secondary.
Just now I pointed out.
You need to sign, you need to file it.
Exactly.
Do it. Do you remember the date?
No, it was reflected in the order, Lordship. The date when this inquiry report was submitted, it was reflected in the order.
123.
Huh?
24, 120.
In a report, but you sign it.
Yeah.
Only because you are here, we are allowing, otherwise we would have discarded this report. Have you given this yourself? Not by somebody else. Dated 24?
123.
24 1 23. Must take it. Has submitted that a reading of the evidence would suggest that there was no opportunity granted to the petitioner to cross-examine. Full stop. It is submit that it also transpires that though the signatures are appearing in the proceedings, where signatures of the committee members are appearing in the proceeding, the same was done in the in form of a questionnaire, wherein there was no scope of the petitioner to cross-examine. Full stop. Para. Rejoining her submission, MS Chakraborty, the learned counsel for the petitioner, by referring to the statement of the university in the counter affidavit, has submitted that the university has accepted that since accepted the fact that opportunity of cross-examination was not given. However, with an explanation that since the purpose of the ICC was only a fact-finding one, there was no requirement to give any such opportunity. In the affidavit, has anything been stated about the members taking the
Not stated.
Paragraph number 24.
What have you stated?
Paragraph number 24, this is with regard to the contention as raised in the writ petition. With regard to the statement made in paragraph 22 of the writ petition, the answering respondents beg to state that the ICC have looked at various aspects of the matter while investigating the complaint. Moreover, the petitioner was asked on several occasions to provide the name of the witnesses from his side, but there was no response from the
No, regarding
the ICC had not violated, not to that extent, Lord, not specific.
Do MS Chaudhary, no. Ms. Chakraborty further submit that there is no denial in the affidavit regarding the averment made that the evidence was taken by only the president, which is in violation of the requirement of the Act and the rule. she submits that though some statements have been made in paragraph 24 or 22 of the 24, 20,
No, 22 of the
22 of the your
yeah, 24.
of the 24 of the affidavit of opposition, comma, there is no specific denial, and therefore it may be concluded that the averments are unrebutted and hence correct. Full stop. Para. After hearing the parties and from a result of the materials on record, including the report dated so and so of the learned amicus, comma, this court is of the view that there is no requirement, that is of the view that considering the ground set forth in support of the challenge, comma, there is no requirement for this court to enter into the merits of the complaint, full stop. As observed above, comma, the grounds of challenge are merely are mostly with regard to violation of the procedures laid down in the act and the rule. Full stop. This court, after perusal of the record, finds force in the argument made on behalf of the petitioner that there has been violation of the provisions of the act and the rule, more particularly rule 74 and 77. Full stop. It is an admitted case that the cross-examination of the witnesses were done without affording the petitioner a chance of no. It is an admitted case that the statements of the witnesses were recorded without granting an opportunity to the petitioner to cross-examine. Full stop. It is all. There is a specific requirement of the rules of Rule 7 within bracket 4 for adherence to the principles of natural justice, which otherwise is also a necessity under the law. Full stop. The averment, the allegations made regarding the recording of the statements of the witnesses by only one member, by only the president in his chamber, also appears to be substantiated by the report of the learned amicus. Full stop. The specific requirement under section 11 of the Act for following the provisions of the applicable service rules, which in this case is the CCS rule, also appears to be substantiated. Full stop. In para. Under the aforesaid facts and circumstances, this court is of the opinion that the report dated 29/5/2019 and 27/9/2019 of the ICC are not sustainable in law, and consequently, the show cause notice issued on the basis of the report is also unsustainable. Full stop. Accordingly, the impugned action in the form of the aforesaid report and the proceeding initiated by the show cause notice dated 21/10/2019 are set aside. Full stop. It is, however, made clear that the present interference is only on the violation of the procedure laid down in the Act and the rule, and this court has not made any comment on any comments or observation on the merits of the allegation against the petitioner. Consequently, while this petition is allowed and the impugned report and the so-called notice dated 21/10/2019 are satisfied, the respondent university would be at liberty to initiate a fresh proceeding under the Act, which, however, has to be strictly in accordance with the procedural later. Before parting, this court acknowledges the assistance provided by the London American MSc who any fee granted to you, madam? Be given or not?
Remuneration not
Not given. And she would be entitled to the remuneration which is prescribed under what? Legal services or what?
legal services.
Prescribed to be paid by the Legal Services Authority.
Well, there are two mistakes.
Mistakes for what?
Mistake one for 7,000 grade payment, which interview I appeared in terms of the order passed by this court, and thereafter 8,000 grade pay, which also I appeared in terms of the order passed by this court. So in 8,000 grade pay, this mistake 220, there was a direction to produce the result before this court in a silk up. I think they have not produced it. Anyway, they will settle these issues.
So since it will be settled accordingly, we'll take note of this.
In the miscases, you write, since the proceeding initiated under the Act and the connected so-called notice dated have been satisfied by this court in the main writ petition WPC 7942/2019, the authorities are required to consider the aspect of grant of grade pay to the petitioner in accordance with law.
He has already appeared in the interview. They will just declare the result.
In accordance with law by declaring the result. And the result of the interview in which the petitioner has appeared would be declared. I stand disposed of. You sign the report. Each page. It was yes.
I could not mention in that.
Doesn't matter.
Because there was.
Doesn't matter.
Gogoi
Gogoi
is on court number 1. I think his presence is required, my lord. I will not ask anything. Only one clarification. I will not go beyond that because he has to be present. Gogoi. Your lordship was saying about 18/11/2015. I also went. I didn't have lunch, my lord. So I have to go to it. Why 18/11/2016? Kindly say para 5. Para 6, my lord. Para 5. Para 5.
5.
At 6.
Yes.
That the gist felt the necessity for constitution of an examination cell for the purpose of being in charge of all kinds of examination. Matter was taken up with the Directorate for grant of approval and constitution of examination cell. In gist was approved by Directorate. Gist opened the examination cell for smooth conduct of all examination, keeping proper record thereof. This cell was also made responsible for evaluation process as per AICT guidelines. GIST has to conduct 32 different university examinations in an academic session under 2 universities, under Dibrugarh University in Assam Science and Technical University as per AICT UGC norm. Now this is important, that those there were post sanction to GIST which could be utilized in examination cell, initially for lack of sanction, that this decided to outsource some of the staff on the contractual basis to be paid from the tuition fees of the student. That in the meantime advertisement, so all this was outsourced by 18/11/2016, and it was urgently required. So they were paid from tuition fees. Thereafter, kindly see that in the meantime, an advertisement issued on 18/6 inviting application from the intending candidates for appointment exam cell on, but there was lack of response. So and so now this, my lord. So these were outsourced, and they were participating in those advertisements which was issued, and accordingly they are appointed on contractual. Subsequently, screening committee has, my lord, regularized it. Screening committee, and by the then director, my lord, who has approved.
No, even before your contractual appointment, you were inducted in the examination cell.
Yes.
That was outsourced.
Outsourced.
By what method?
That's why no, this outsourced they want very urgently, they required. So
no, why you? Why not Mr.
No, it's right, my lord. There may be some others also. That they will, I am not saying that's why.
Or were you working in some other field, other
My lord,
department? You were just
in employment, right to employment starts with an advertisement. Everyone has got the right to participate.
no, we may not find too much of a defect because this is examination cell. The duty is only for a few days. So there may be, you may induct somebody for temporary period. But while doing so, you could have done from this existing staff of the college, of the university. You have taken resort to 3 persons who are not connected with the university at that stage. 3 persons came into your contact, their contact only after their contractual appointment, which later one was regularized.
Yes.
Now,
my question is, my lord, my question is that whatever may be, contractual.
Is this lady a party in this proceeding?
Which one?
The director.
Sure.
The dead director, her name, Mausumi Borua. Not a party.
Director Technical Education is
She by name was not a party.
No, it's not, because we made a case, we have filed a petition. Our appointment, what they have said, my lord, when my services
Now,
were
if
regularized,
she has denied that she has issued any such approval letter,
she has not denied. She has not denied. What the government is saying, he then director what powers he has got. And these are all fake. He didn't deny. It's a fake. Because you don't make. What has happened? When this was done, my lord, my
no, there
regulation.
are two. There will be two connotations. One is a fake paper, which is a non-existing paper,
Yes.
and one is a paper which has been done, issued without jurisdiction. Maybe director was not authorized, but she had issued.
Yes.
That will not be a fake.
Yes.
That may not be a legal paper, but fake is something which is fraudulently introduced.
No.
They have LS fake.
No, I know, but we have given a reply. We said similarly also there are appointments which have been made by department by same director technical. Fake is something, my lord, where an inquiry has to be made. Whatever may be, my lord, why? Now there is an inquiry against Mosami, that the DD director technical, and again their so-called was issued. On the basis where an inquiry was conducted, we have been terminated without giving any so-called. That's our case. Give a reason, give a so-called to us.
No, inquiry was against that director.
Mosami, yes.
Where?
Yes.
Where?
Kindly see, we have given an affidavit.
Some additional affidavit.
Yes, yes. My lord, will kindly see the government affidavit for a moment. Government affidavit for a moment.
Yes.
Now kindly see the termination order which was issued at page 47 in my repetition. 47. One year your lordship will take my repetition at page 47.
Yes, please.
Kindly see, in compliance of government order, by dated dispute 22nd of June 2021, services of the following person in Jorat Institute of Science and Technology are hereby terminated. So there is a compliance of the government letter on 22nd of June 2021. The Director of Technical Education has terminated my service. Correct, my lord? Now, if your lordship kindly see the government's affidavit at page 53, this is 22nd of June 2021. At page 53.
53
of the affidavit filed by the government that one Otul Bora has filed. Dr. Otul Bora man.
Yes.
At page 53.
Yes.
At page 53, kindly see 22nd of June.
Correct.
So this is a letter with reference to this addressing to whom, my lord, from so and so to director. With reference to subject cited above, I am directly requested to furnish a statement of allegation, list of document, list of witness to start disciplinary proceeding, and also request to terminate the service of person appointed by Dr. Mausami Barua, Dean and Director Technical Education. So, my lord, these appointments were made. Government is saying how these appointments can be made without we being known about those appointments. There is no approval from the government side. It is an approval which is made by Dean and Director. So they got annoyed and said, we will have to start disciplinary proceeding against the Dr. Mausami Barua at page 53. On the basis of this, my lord, our services also was terminated. All appointments made by Dr. Mausami Barua, the petitioner services were terminated. This is at page 47. This is what I understand, my lord. And at page 24, government affidavit himself, my lord, at page 54, this is what they have annexed the termination letter.
The principal was also proceeded against Vivekananda Chaudhary.
Where, my lord?
Of the institute.
I'm sorry.
The principal of the JISP was also proceeded with because of all these anomalies.
Yes.
You come to the affidavit of the government page, internal page 12.
12. At page 11.
Internal page 12.
Internal page 12. Yes. Sir, lordship, kindly see at the same
paragraph 3, last part.
Yes.
On account of the illegality.
Now, paragraph 3, my
lord. Last
yes, for first, my lord, will kindly at page 11. On account, at the same time, at page 11, at the same time,
yes.
Finally see 24, my lord, at page 11. The government of Assam in higher education technical serve notice number so and so, seeking clarification from Mausami Barua, Dean and Director Technical Education as to the appointment of three petitioners. Government could not be satisfied by the clarification furnished dated 7th of April by Mausami Barua, and government research start departmental proceeding again Mausami Barua by so and so, which is in progress. At the same time, in connection with similar irregularities, appointment in other 6 number of grade 4 employees of these who were appointed by so and so, citing the so-called approval letter issued by Mausami Barua, deed and director technical education in charge without necessary approval of the government. Government has directed the director of technical to terminate them by letter dated so and so. Accordingly, has directed the principal so and so to comply the government's order immediately, and they are terminated already. On account of illegality made to appoint the sixth person in the line of petitioner case, government has decided to take disciplinary action against Vivekananda Chode, principal of this. Maybe, my lord. What I am saying, my lord, maybe there may be some appointment which has been made, maybe contractual also, and screening committee also has regularized without following the procedure, maybe. But at least my termination should have been followed with some notice. Some notice has to be served. This is my whole case. There may be, my lord, kindly see some order, my lord, there. It's not a fact. It is not the case that Mosai Boro has not appointed her. But she has not taken approval from the government. She was the deed and director. Kindly see, that's what they have stated. Kindly see at page 11, my lord. My lord, at page 10, kindly see the last part of the paragraph, page 10. In view of the above, government was reported the fact of the illegal appointment of the petitioner since temporary engagement on the basis of report of deputy commissioner. Fact-finding team same is in public domain. Finally, in the compliance of the government dated 22/6/2021, service of a petitioner were terminated dated 24/6/2021 as due procedures such as prior approval of administrative department, finance department, wide public advertisement, written test interview, etc. were not followed while they were appointed on regular basis by the director insert technical education Assam. So at least what they are saying, if you make a regular appointment, there has to be an advertisement for the post. My lord, I am telling, I also agree to. There cannot be any, without an advertisement, how can regular appointment take place? Contractual very well, you can do it, but regular appointment has to be first starting point is right to employment by an advertisement. It's right, my lord. I don't support also those petitioner has been screening committee constituted, their service regularized. No, it can't happen. Contractual appointment, I understand. But only terminating me from this service, at least they could have terminated. They said that your services as regular employee cannot be taken consideration. Continue as a contractual employee. That I understand. That they have not done. Enter my contractual also goes. At least my regulation part, that is illegal. Maybe because there is no administrative approval, there is no financial approval. But terminating me from contractual was also illegal, my lord. They themselves stated in this at page 10, there is no administrative approval, there is no financial approval were not followed. And how a regular appointment can be made?
Your
Once-
contention,
Yes.
if we accept the entire version of the department, is that since the problem is with the approval part, and approval is required only for a regular appointment. If that goes also, your status as a contractual employee should be maintained.
Yes, that's my, I also.
Termination, even from the status of a contractual employment, that was not even the subject matter of approval.
Why the government said, how a regular appointment can,
Who has to answer?
I think Kostok should be heard by this. He is there in this case. He also requested that he should be heard.
No, definitely we'll hear him.
Yeah.
But
Kostok is there.
when?
Any date, my tomorrow also I am there.
Tomorrow again, Friday.
Only one request is being made by. Only Monday, Tuesday I will be Isle, and on Thursday, my
We'll also go to Aizel to hear you,
your lordship is
along with the record. Your part we have we have understood.
my lord. If your lordship take into fake appointment.
No, that part we are clear.
No, what?
Had it been a case of fake appointment, our views would have been different. Now here it appears that Barua was in the he was in the know of things. Only her approval, only her competence has been questioned by the government. Government has said that you did not have the authority of the government to make the approval. Had it been a case of a fake, that even Barua was not aware, papers have been manufactured, then our views would have been different.
Well, for the
Now, for the
moment,
lack of approval,
my contractual should not go, man. And my lord, my argument is that even
now
for
are
the
you
moment,
protected by any interim order? No.
no, not because on the threshold of it, the court says it's not that your lordship can give a direction that if they consider my contract, they will consider. Because I have been told that these particular all these three posts remain vacant as on date.
But is there any requirement of this post? That is
These
also
posts
one
are
question.
required because these posts only can be stayed by the principal here.
Yes, principal is appearing.
They are the best person.
Has the JISK appeared?
I think they have comment on the part. Can appear there. Jora we made a party. I think, my lord, they were the.
Has somebody appeared? Mr. Willer?
We can appear.
Okay. Who has filed affidavit in this case?
The government has filed. Government.
I think government will take care of the thing.
Google will be the best person. He has been pursuing the matter. The record is also with him.
Thursday will fix.
I can fight it. Malot is there. Like
No, we will not like to prolong this matter. Thursday, your part, you
I am not there.
Thursday, you said Monday and Tuesday.
No, again, Thursday in Kohima, one matter, partner matter is going on. Friday can be taken.
Friday will
Yes.
try. And tomorrow also we can
Tomorrow,
try.
yes, no problem. Tomorrow,
Tomorrow?
no problem. I am there.
Because today we have some meeting, we have to rise early also.
Tomorrow,
Tomorrow. Vice Principal. I heard they need a in account for the petition. However, a prayer for accommodation has been made on behalf of the Training Council. Higher Education? Higher Education Department. List for further consideration tomorrow.
I'll just hear the other side, then I will. If departure is right. Well, I was worried about the only contractual, not that part. We have also denied about this fake account. We have given a reply.
3227.
Okay. I'm paying for respondent number 2, our affidavit has been.
It is ready otherwise.
Pending for signature.
Let them file it.
I pray that it takes
We'll repeat it.
it's a question of repetition of the
Yes, yes, your name? You repeat for whom?
Statement number 2 on behalf of Mr. S. Botagomar.
Sri D. Gogoi, Learned Council, appearing on instruction of Sri S. Bothakur, Standing Council, ASTU, submits that the affidavit in opposition is ready and can be filed and would be filed shortly. Full stop. He accordingly prays for and is granted a week's time for the same. Full stop. Para list on 7th of June.
Lordship, can it be on 6th, Lordship?
6th is a Tuesday. Okay, Tuesday, 6th. Can you dispose it of?
Lordship, I pray for disposition.
You file it before that. Okay, don't wait.
Let him file Lordship by this week, Lordship, so that I, if anything, it should not.
This week not
On
possible.
Monday, on Monday, next week will Monday. Then on 6th.
Yes.
Hello. Much obliged, Lordship.
Won't tell you. Urgent matters. We have to rise early. Any urgent matters are there?
Well, not only this in this item, but I need 1 week time to file the affidavit in reply.
No, that is not urgent. Those will be given.
Only the
Mr. Mazumdar, which is your item?
well, next date is required.
Date will give.
On 8th for the department.
34, 35.
What are these matters?
We have challenged the promotion order as well as graduation list.
How?
Of head teacher in the ME school of Kashar.
Who is it? Mr. Purkasta is appearing.
Yes.
No. Senior Purkasta, where is he?
No,
he was there.
That is again in another. This is different. Okay. On Tuesday,
Okay. Oh, you are the petitioner here.
I am for the petition.
Okay. No, we'll fix it. There's no problem. Why Senior Purkasta is there? Which matter? 21.
It may require some time because I have been directed to.
Why I thought you were sitting, you wanted to do a case. You're for adjournment.
No, I'm not for adjournment, Lord.
And let us do that case.
I am otherwise ready, my Lord.
Okay, 21. Last case.
Well, item 20
Now 21 we are taking, thereafter we'll look into. Oh, you are the respondent, therefore you are ready. This is for the petitioner.
I am for the petitioner.
Yes.
better pertains to the result of HSLC examination. Yeah, 2021, my Lord. Instead of physical examination, my Lord, effort is for the guideline was issued. The Lordship will find.
What is your grievance?
My Lord, as per guideline, marks are not awarded to the daughter of the petitioner.
Marks were not given in the HSLC examination. Mr. Purkasta, you are for whom?
My Lord, basically, my Lord, at the outset,
You are for whom?
I am for the respondent number 10.
Who's 10?
That master of the, my Lord, school.
Who's for the council? Yes, higher secondary. Yes. What do you say? What is the grievance? What is the grievance?
My Lord, regarding my Lord, marks awarded by the school evaluation committee for the year 2021, HLC examination was not conducted by the SEPA. The marks were issued on the basis of the marks provided by the
2021. COVID period.
Yes.
Okay.
The
It was done on the evaluation made by the school.
School authority.
Okay. Then what had happened?
Then my Lord, in our affidavit, my Lord, we have.
So who will have the role? School will have the role.
School, yes, my.
You don't have much of a role.
Yes.
Yes, Mr. Purkasta, what do you say?
I'm just making it clear, madam.
Mm.
There are 3 different committees.
Mm.
One is school evaluation committee, one is my Lord, district level scrutiny committee, and another is grievances, my Lord, redressal grievances committee.
Correct.
And my Lord, I am the headmaster of the school.
Mm.
A submission was made by the standing council of my Lord Keba. That it is the respondent number 8 and 9 who are otherwise accountable, my Lord, for assessment of the mark.
Who's 8 and 9?
8 and 9 is my Lord.
District level.
Oh, yes, my Lord.
And
2 committee.
Hmm?
And so far the headmaster of the school is concerned,
Hmm.
at page 21 of the my Lord writ petition, I am not part of the committee. I am supposed to be chairman of other school. Therefore, so far as the committee is concerned, who make the necessary assessment, I did not have any rule because I am the custodian and I am the record keeper. Therefore, I was directed to produce the record. This one.
No,
Even then,
the school has been made a party number 10.
the school was made a party.
What is your role in evaluating the result?
I don't have any rule, madam. Lordship, kindly see.
Then who evaluates the assessment?
Committee is the madam.
Which committee?
Committee is school evaluation committee.
And district level. What is the school evaluation committee? Then the district level.
School evaluation committee is made party.
Who is for 9? 9 has been served or not?
Yes, madam.
Served. The test for Dusty has not been taken. No steps for Dusty. Oh, state council for 1 to 9.
Yes.
10 has already appeared. So Dusty is not. Yes, 1 to 9 state council.
Lordship will have page 21.
Because the version of the school you have heard, they do not have much of a role in assessment.
That apparently is not totally correct. Lordship will have page 21.
Who gives the initial mark? The
My
school.
lord, here the committee, school evaluation committee is to be appointed by the inspector of schools of the concerned district. I appoint a particular person on it. Committee members are there. These committee members who consist of the class teacher of each subject of that particular school, one teacher of that school having computer knowledge and maybe co-opted and all that. It is the school who gives the mark. I only appoint the chairman, the inspector of schools. The headmaster now washing his hand off, not going to do it. His teachers are
who is the
doing it.
chairman?
The chairman for this particular committee, my lord, I recommended. The committee. The committee members.
So you have the proceedings. You have the proceedings. What is your allegation? What mark? How much mark you?
Kindly page 21 last, my lord. There are procedure, my lord. How marks to be awarded.
Page 20?
Page 21.
Yeah.
Sorry, my lord. Page 24, my lord.
24 years.
My lord, last, my lord. Close there, my lord. Bottom, my lord.
24. Yes.
Bottom paragraph.
Yes,
For
please.
students who are evaluated through the annual examination of class 9 and 3/4 of the revisionary test held for class 10, the following criteria are to be followed. 40% weightage on marks secured by the student in the theory portion of each subject in the annual examination of class 9, year in which he or she has appeared and promoted to class 10. Next, my lord. 40% marks secured by the student in theory portion in each subject. My lord, basically 40% from class 9 marks and 40% from pre-board examination and then 20% by the school authority. Now, my lord, question, how much marks he secured in class 9 examination? In this regard, they have
What is your claim first? Let us know.
exact marks were not given to the
What is your claim?
claim, my lord.
How do you know the marks given is less?
Yes, my lord. This is, my lord, petitioner got in only one subject, my lord. Page 28, my lord.
28.
Page 28.
Yes.
He got 21, my lord.
In
a
Bengali.
Bengali, my lord.
Yes, then.
Now, my lord, kindly see for how much marks he secured in class 9, my lord. It is reflected in the affidavit itself, my lord. Affidavit in opposition of the school, my lord.
Tell us.
Yes.
Now, according to you, how much should be the mark?
So, my lord, mark was awarded as per the guideline, my
Yes.
lord. Would have marked the exam.
Lordship will kindly have page 28 on every subject it is failed. He is pointing out one subject.
No, my lord, for just only one subject I am coming one by one, my lord.
page 20, page 14 of their affidavit in open.
No, for all the subjects, you say that the assessment has been wrongly done.
Yes, my lord. In every subject.
Why affidavit in opposition which
Page 14, my lord.
1-4?
1-4, my lord.
Yes.
Your lordship will find page 14. Petitioner name appeared in serial number 120, my lord.
120.
120. Sorry, my lord. 122. Last, my lord.
Yes.
Hena Begum.
Yes.
Tapadar, my lord.
Yes.
Your lordship will find in MIL column, my lord.
MIL.
MIL column. Theory, she was shown got 15, my lord. And class 10, my lord, 23. And then 6, my lord. Now, my lord, come to page 22, my lord. Page 22.
20?
22, my lord.
Of the state affidavit.
State affidavit. Your lordship will find serial number 31, my lord.
31, yes.
31. In Bengali, my lord, he got 23, my lord. He got 23. 23 in pre-board examination, my lord.
This is pre-board.
Yeah, this is pre-board test examination.
Okay.
Now, if he got 23 in pre-board, my lord, and 34 in class 9, my lord. 34 in class 9, my lord.
This is Bengali.
Bengali, my lord.
Bengali. This Bengali is MIL or what?
MIL.
MIL.
Is Bengali, my
Class
class 9.
9, you have got 15. No.
15.
15, class 10, 23.
Yes. 15 plus 23 would be 38.
No, my lord.
And out of that, you have to take 20%, which makes it
No. 15 class 9, my lord. Then your lordship will find 23 class 10.
Yes.
Then in page 22, it is. It will be better, my lord. It will just make it fair, my lord.
Let's try to appreciate what you say. At least one paper will be clear. See, let us make a chart. For one paper only, Bengali, okay?
Yes, my lord.
Bengali. Class 9. Class 9.
Class 9.
15.
15, my lord.
Class 9. 15. Class 10.
10, 23, my lord.
23.
Yes, my lord.
Pre-board. Pre-board. Bengali. 23. Pre-board 23.
23, my lord.
Yes. Now what is the procedure?
Now procedure is, my lord.
Where is the procedure?
Procedure 40%, 40%.
Of
both the pre-board and class 9, my lord.
Oh, what about 10?
It is 80%.
What about 10?
10, my lord. Ten is not there, my lord.
No, in page, what is this 20? Oh, 23 is the pre-board.
Pre-board, my lord.
Okay. There's 15 and 23. 15 and 23, how much is the percentage? You have to.
15 and 23, 38, my lord.
No, what is to be done now?
38. Out of
what is the procedure?
80% of 38, my lord.
No, where page?
20% of 30.
No, wait.
20% of 30.
No, we'll do the exercise. Where is the page?
Page, my lord.
Procedure.
24.
24, yes. Okay, 40% of the marks secured by the student theory portion of each subject class 9. In which he has appeared in progress. You take 40% of class 9 of 20 of 15, that means 40% of 15. How much it is?
6.
6. Then 40% of the marks, theory, 3 board.
23.
40% of 23.
It will be 9.
9. 20% of the marks equal to student theory percent each subject in unit test. Unit test, how much mark?
We test not everything. Not 20% of 38.
Unit test, you got 38.
Yes. 20% of 20 plus 15, 38. Then we have to calculate maybe on the 20%.
Now 20% of unit test.
Unit
No separate mark of the
Unit test is a different mark. So 20, it should be 20% of the unit test. How much marks is equal in 20 unit test? Unit test,
In
how many?
Bengali, there was no unit test, so marks were not taken for the unit test. These
Average was taken.
These two.
20% of how much?
20% of the benefit not out of 38.
No, not out of 38. 38 divided by 2. 38 is total marks. How can you have 200 marks?
38 is not plus 9 and plus 10.
You cannot take the total, you have to take the average. 38 has to be divided by 2.
Unit test
Is 19. 20% of 19. How much is 20% of 19?
19 to the 38. 19 to the 38, 3.8.
Huh?
3.8.
3.8. So marks of this is 9 plus 6, 15.
Plus
18.8.
18.8. And thereafter, we can give 20% variation. An advantage we can, the school could have given, which if given, if we take this to be 19, the variation comes to, variation along with variation, it comes to total 21 marks. Mark sheet lordship will find we have given 21. She should have got 19. We gave an upper variation.
Of 20% maximum.
Yes. 20% we can vary. That is what the we make it 21.
My lord, matter of day after tomorrow, my lord. I have
And the marks you have secured
my lord, I have
are fantastic.
Yes, my lord.
In 9, 10, almost single digit.
No, my lord.
I was only
If
telling.
she got in every subject 15, 10, in
But
class
you have
9,
the guts to come to the
she was
court.
promoted, my lord. This is also doubtful. Class
Will award you a prize for coming to the court with this mark.
He was given medal constitutional mark plus 9.
My lord,
Then he
matter
was
of
promoted plus
on
10.
Tuesday, my lord. In the meantime, my lord, I will.
You have a lot of confidence.
I was telling my senior friend here, my lord, it will be putting a seal on her failure.
My lord, on next Tuesday, my lord, I have to.
It might reduce also. You have already failed. Now you will fail twice. Once in the matric, once in the second time in the court. Withdraw this. We have given more than time necessary.
And madam, there was
Only because some mathematics, arithmetic was involved, we took interest. Otherwise, we would not have taken interest.
Only Tuesday,
If the antecedents of the marks of the secured by the petitioner in 9 and 10 would have been something exceptional, we would have definitely looked in. We marked like 9, 18, 20 out of 100. Don't expect.
My lord, I have to submit, my lord.
No. This is not the purpose of 226. To look into waste our time with this kind of matters.
No, my lord, I have.
You come up with a case with merits, we'll definitely look.
No, my lord.
See your marks.
Yes, my lord.
How much mark are you securing?
I admit.
You secure 15 out of 100. You secure 23 out of 100. And in the matriculation, you fail and you say that marks.
Only question, I have to.
What is there to decide? We have made the
No,
calculation in your presence.
I admit, my lord.
Then admit, then we pass the order. Don't come up with these matters. Why do you advise your clients? It's sheer wastage of time. Third. Read. HMR with other item number. HMR Chaudhary. Senate Counsel for the petitioner. review. We'll pass order the 10%. We're discussing it. We have to rise. There's some meeting. And other cases where urgency is there, court must give dates. Any matter where interim order is still today? Mr. Goswami, any interim order till today? No.
There is the item 25, Your Lordship, because it's a very serious issue and it's a hard-hitting issue for the.
No, he'll give the date.
Monday, Lordship.
Monday, not possible. Monday, this month.
Lordship, just give me 1 minute time, Lordship. I'll convince Lordship why this case.
No, Monday is not possible. All cases are urgent. Monday is not possible.
Employees, Lordship.
Monday is not possible. Try for.
Died, Your Lordship.
Huh?
Expired, Lordship. And since 2015, they are not given any penny for pension, Lordship.
We'll have it next week, not Monday. Not Monday. We'll try on Thursday next. We can have it for. We can go for disposal.
Yes, Lordship.
Thursday.
My Lord, item 23 also again is the concept on
Not Thursday. One case we have. What is your urgency here?
NOC not even to a college, my Lord. It is running, my Lord. The court, my Lord.
You'll have next week, not this, not next to next.